The matter was appearing as item number 75.
75.
Yesterday. Today, the matter is appearing as 32.
So it will be taken up. Don't worry. You wait.
If it is not taken on the
My lord, I shall be paying for inclusion of one matter, mandamus appeal.
Inclusion, you give the slip.
My lord, there is a precedence, my lord. All petitioners, appellants are senior citizens. My lord.
Give the inclusion, it will come in the monthly list.
My lord,
My lord, appellants are all senior citizens. My lord, kindly have a precedence.
25 is an assigned matter, my lord. But my lord, Mat 942 of 2026, my lord, is already a part matter by Honorable Justice Banerjee, my lord. And both are connected matter, my lord. I'm praying for analogous hearing, my lord.
When that bench is available, then you mention what can be done today. When we take it up, you mention. You want it to be analogous with that matter?
Yes, my lord. Both are connected matter, my lord.
Maybe, but it's not a signed matter. So if whatever is decided can follow in this case.
My lord, may I?
But that's not a regular bench.
My lord,
When we are sitting, then you may mention. We'll see.
my lord, kindly release this matter, my lord.
Huh?
Release, my lord.
Release
My lord.
this matter.
2324 of 25, my lord.
The one you want to be analogous.
Yes, my lord.
Where is it listed?
My lord, it's already part matter, my lord, in group number 8, my lord, by Honorable Justice Banerjee, my lord.
I'm unable to appreciate what you're trying to say. Once you said it is assigned, now you are saying it is parted. We don't know.
My lord, 2324 of 25, it's an assigned matter, my lord. But the connected matter, 942 of 2026, my lord, it's already part matter, my lord.
So you want this to go with that matter?
Yes, my lord. Both are connected matter, my lord.
If it is connected, then why it has not been listed together?
It's a department issue, my lord. 2324 of 2025.
Both are of the same year.
Yes, no, my lord. 2324 of 2025, my lord. And the connected matter 942 of 2026, my lord.
No. When it is taken up, we'll see. How can we direct that it will be listed before another bench?
May I have your Lordship's kind leave mention a new intra-court group 6 appeal matter. New matter.
New intra-court appeal. What do you want?
Inclusion.
Yes, give the inclusion. We have already.
May I permitted to mention, Your Lordship? Lordship, this.
Oh, where it will go?
Service matter. My lord, group 6.
Where it will go? Which is the
Group 6.
oh, where is that matter going to go? Where it will go? Group 6 new matter. So where it will go?
Group 6 though.
Lordship, this matter is for compassionate appointment. I am praying for inclusion and urgent listing of the matter.
Is it arising out of single judge order?
Yes. Yes, Your Lordship.
Included will be included in the monthly list. You give it.
Pardon?
It's not on the list.
It's not on the list.
Give it.
Lordship, may I be
Lordship.
permitted to mention, Your Lordship, the matter was at serial number 119 yesterday. Today it is not in the list. The food inspector.
119.
19. It has gone down to 119 from serial number 17, Your Lordship, during the last few days.
So how much? It should not be much. It will come up. Don't worry.
Any day, Your Lordship, it may
We'll
be.
see. No prioritization. Item number 1.
So the translated copy you have
Okay.
given.
Yes. Yes, sir. Yeah. हम पढ़े पढ़े रहे ठीक है नहीं ये बढ़िया
There is the duty, rights and obligation rules.
That is the annex.
100
That rules are annexed to the 1980.
144 sir my lord 144
Yes, you say, sir. Don't worry about my lord. You may say, sir.
thank you sir.
Yes. Yes.
So it is a simple case of to not giving you the benefits of the 8-year benefits which are completed successfully. So in root cause is which as a executive magistrate performed due to 2019 and 10/12/2019, which is stated at page number 6. And this is the root cause.
What is the date of punishment? Where is the punishment order?
Punishment copy?
Punishment order is at page 130.
Final punishment?
Earlier. That's it. 120,
130, 133.
156 actually, the final report.
It is final, sir.
That is the final report. The punishment.
Punishment, final punishment.
That's what it is.
Mhm,
Lordship 133.
No, 133 is the second show cause.
Sir, 121. punishment. And proposed
141.
punishment 143.
141. I stand corrected.
141.
141. Punishment is 141.
Mhm.
Two increments without cumulative effect.
Yes, sir.
There is no appeal.
Find any documents.
No. I raised the punishment. I approached this site and there
Now that we are seeing, therefore we are asking, there was no departmental forum.
this is actually not because the government is the final appellate authority, but
Is there any revision provision?
division provisions, no, sir. As per the appeal provisions is there, they are for other group B or group C, but in group A can, who is and as per the use of the governor, they can directly move to the administrative tribunal. If this not
Has to go back.
comply with, then we can approach before your lordship.
No, there must be a review or revision.
Review option,
There is?
There is a
appeal
Must be.
option is there, but
Huh?
appeal option there, but not a review option.
No, you will not have an appeal because your order is passed by the governor. So therefore, there must be a review or revision. Where is the rule? Let us see.
এটা একটা আছে, এটা একটা আর একটা আছে, আমি এইটাই তো, এটার কথা বলছেন? এটা 30, এখানে কিন্তু বলা আছে শুধু অ্যাপিলের কথাই বলা আছে। এটার সাথে হ্যাঁ একটাই আছে, একটা ওটা দিয়ে দিন, ওটা দুটো লাগবে না? ঠিক আছে, আমার কাছে এক্সট্রা নেই, আমি শুধু যেটা মেন লাগবে। 5 মিনিট।
এই বইটাতে
ওইটাই তো নেই তাহলে। Actually, this is the main portion which I
এটা কি
ওই যে ডিসিপ্লিনের পার্ট, ওই যে মেয়ে কথাটা বলা আছে না, যে যদি ওই পার্টে
একটাও
এটাই মেন, মানে বেটার এগেইনস্ট আমার কমপ্লেন আছে।
এটাতে পেনাল্টিজ,
পেনাল্টির উপরে কি গ্রাউন্ড থাকতে হবে, ডিটেলস বলা আছে।
পরে আরো আছে
আরো আছে ওইটা।
এটা দিয়ে হবে।
Yes, Rule 22. Rule 22 provides for review. Why you did not avail this remedy before going to the tribunal?
Actually, I wasn't there how to appeal in nature, and before the governor, I don't able to any take any advice or any substance, or already the 6 months as gone through.
You see the provision, Rule 22.
It is a group it is review only able to check. It is first of all 6 months না কতদিন একটা ছিল।
No, time, we are not concerned about time. We are asking you, if there is a remedy, then why you did not avail it? Why you went to the tribunal directly?
There is also one point I mentioned. The point was raised by opposite party respondents at tribunal. Then I raised the point that the opposite party, and they told that it's this governor who is such a reviewing or appealing authority as such a Padupal against the government. Hence, I decided one matter is related to governor. So, as he is a party, then I decided not to approach before him, which was I addressed before in tribunal.
He is a party.
Party, no, that was related to government. If as in this matter is related to government, if you respect the constitutional, that is government. Person can expect respect from others.
So it is nothing against the governor.
But the opposite party can go that he is a governor, is related to governor. How can
There is no likelihood. There is no reasonable likelihood of bias. There is no allegation against the governor. You are a deputy collector.
Yes, sir. Yes. Many other instance was there that if anyone is group officer, he can directly approach this to SAT. If SAT is
Where is that provision? He can directly, any officer can directly approach the SAT. Where is that provision?
sir, one thing also, the governor is pleased to appoint. Governor is pleased to appoint, and then how can I approach before governor? It is one also my doubt. This is also, sir.
Things will not proceed on your doubt. Things will proceed on the rules.
Yeah. Sir, this is point 17, sir.
Where you have seen that officer can directly move the SAT without exhausting the remedy? Where is that, you said? Which provision you are relying upon?
In point 17, sir, period limitation of appeals, there was only 3 months.
You are jumping from one point to the other. That will not help you. The first thing you said that there is a provision that officer, if he is officer, he can directly move the SAT. Where is that provision?
No, that was not.
That is not, we know. Therefore, we are asking
Yes,
you.
yes,
You
sir.
said you were wondering maybe we have missed, but we have not missed. There is no such provision because how one has to approach the SAT is regulated by the Administrative Tribunals Act,
Yes, sir.
which says you must exhaust the remedy before you go before the tribe. You must.
Yes, yes.
That is a requirement under section 2021 of the
Yes, sir.
Administrative Tribunals Act. There is an issue. Your only defense is that it is not in discharge of my official duties. We have gone through the things. The disciplinary authority, however, found that your behavior is unbecoming of an officer, because you should not be publicly voicing your such views.
Yes.
That is the, we are not,
Mhm.
which is correct, we don't, we have not examined, but this is what it is.
Yes, yes.
So why you have not gone in review? You could have filed a review. They could have considered your, it would have been considered again.
Sir, actually, what happened, sir, in this in 3 month time already elapsed, sir.
That we can do even today, we can direct it is to be considered. That is not a problem. That can, we can.
After that, a second I did, as time already last, sir, I approached into the governor's, but unable to, unable to access how to apply the.
You are a deputy collector, you don't know how to file a review.
No, sir, I approached, but they said no, there is no any provisions of court in governor, honorable governor courts.
Can anyone say like that contrary to the rule?
Hmm.
Can you, when you are sitting office, can you say anything contrary to the rule? You cannot.
Yes, sir.
Likewise, anybody who is sitting in the office of the governor or the governor secretariat, he can't say anything contrary to
To
that.
approach before other head officials, but unable to depart from doing this.
Where you have said this?
They said that you have to get permission from department, from governor. Takes time. Already time lapse is
Permission for what?
and to approach to officials about this matter, discuss about the matters.
Which officer? You cannot approach any officer. You have to file a review before the governor. Which officer? We have just shown you rule 22.
পিটিশন হ্যাঁ এটা রিভিউ করতে বলেছে না অ্যাপ্লাই করা হয়নি কারণ আমি দেখিনি কিভাবে
Either on his own motion or otherwise. That means you can apply. Call for the records of any case, review any order which is made or which is made or which is appealable. So both nature of orders can be reviewed. Or appealable orders and any order which is made. Under these rules are the rules repealed by Rule 24 after consultation with the Commission. Again, he will take the consultation from the Commission. He can confirm, modify, set aside. He has the wide power under review.
Yes, sir.
So why don't you avail that remedy? Let him
go back.
you avail that remedy.
Let it be, let him file a review and then they can consider.
So this matter already approached opposite party respondents in SAT. Then after after hearing decided that allowed to proceed on in the SAT case. এখানে দেওয়াই আছে
Take it back, let him file a review, and then the entire thing can be considered. What his grievances, otherwise lordship will.
If he is not willing, let us see. Where is your reply to the second show cause?
show cause one time show cause.
Second show cause.
Oh, acha, second show cause. Yes, sir.
Page 135. 135.
To 130, 140, sir.
Lordship, আচ্ছা আমি একটু পরে গেলে সুপ্রিম কোর্ট চলে যেতাম
তখন নিজে পদ্মপাল বলছে কোনো মানতে চাইছে না, এরাই বসছে ওই ইয়েতে। আচ্ছা আচ্ছা আচ্ছা। না এখানে যদি হয়ে যায়, কারণ আগে অলরেডি যেহেতু স্যাট অ্যাপ্রুভ করেছে, ওদের এই বক্তব্যই ছিল। স্যাট বললো না, এটা প্রভিশনস আছে হাইকোর্টের সাথে।
পরে আপনার স্কোপটা লিমিটেড হয়ে যাবে। এখানে যদি হেরে স্কোপটা, এখানে হেরে গেলে আপনার স্কোপটা লিমিটেড।
আগে তখন পয়েন্ট আমার জেনুইন ছিল।
Where is your reply to the inquiry which you submitted before the inquiry officer?
ইনকোয়ারি অফিস, হ্যাঁ
Where is your reply which you submitted before the inquiry officer?
which was 140 sir, which was translated in vernacular language, because the Facebook comment was made on vernacular language, which was translated in English by Honorable Court's Translation Department. Page number 2. Translated copy, page number 26, sir. And noted page number 1.
Where you have raised this issue in your reply before the inquiry officer, where you have said that this is not in discharge of official duty.
Already I mentioned that.
Where it shows from your reply, it is at 114. Where you have said that this post is not a part of my official duty, or that it does not come within Rule 3.
So in last
page.
Again. Page number 2, sir.
Page number
2. In translated copy, sir. In connection with framing aforesaid charge, I state that the allegation made by 8 quotation.
Yes.
Sir, in last paragraph, in connection with the framing of the aforesaid charges against me, I state that the allegation that that 8 quotation of the to have constituted the breach of section 3 under 3 and 2 of the West Bengal Service duties, rights and obligations government.
You are saying that it is not derogatory, or that it is not going to propagate any kind of hatred or such things.
Yes, sir.
Where you have said that this does not constitute a misconduct under 3. Your whole before the tribunal and before this court,
Yes, sir.
you are saying that Rule 3 will not apply because this is my personal expression.
Yes, sir.
It is not part of my duty.
Yes, sir.
So where you have said this, unless you said it, how the inquiry officer could consider such thing? Because you have later on you have also made allegation against the inquiry officer that he is predisposed or he is acting with some kind of malefied or ulterior motive. So therefore, we are trying to see, did you raise this issue before the inquiry officer?
Already, sir, I in the past shows, which was included already in the shows,
Is your reply to the charge memo?
Yes, sir.
114 is your reply to the charge memo.
Yes, sir.
So this is the place where you have to say this. So when you said this, see, before the High Court, please understand something. We are not appellate forum. We will not go into the merit of the charge. We will only see if there is any violation of procedure, or if there is any miscarriage of justice occasioned by violation of principles of natural justice. If something you have said has not been considered, that we can also say. But we are unable to find where you raise this defense. That this is personal expression and has nothing to do with official discharge of duty. Where you have said this? Have you said anywhere that this is my personal expression? I am an officer of the state. In discharge of my duties, this shall not come in the way. This is a personal expression. Anywhere you have said this?
Already, which is enclosed, sir. In the first,
We have gone through this, your written statement, 114. We don't find any such plea taken by.
He said that it is not in violation of rule 3.1 and 3.2.
Oh, that's all.
sir, in the first,
So see, please try to understand what is crossing our mind. We have not decided, but we are just, that's why we are asking you. True it is, nobody can deny that you have an individual right to expression.
yes, sir. Yes,
That cannot be denied. That's a constitutional guarantee.
yes, sir.
But no fundamental right is absolute.
Yes, sir.
That also
Yes,
it is subject to social and interest and public interest at large. To some extent, it can be regulated or in any way. The Constitution itself, there is it is provided that under the Article 19 itself, that insofar as your expression does not offend or hurt any other sentiment or vitiates harmony or it violates public interest, you can do it. But then another factor with you is that you are a state government officer.
Yes, sir.
Your perception makes a difference for the society because you are there to enforce the law. So therefore, we are trying to see from your reply where you have said anything on this aspect that look, I am a government servant. I know my duties. In discharge of duties, this shall not come in the way. This is purely and separately my personal expression, and it shall never come in the way of discharge of my duties. Where have you said this?
Sir, it is not which I said, sir, in first reply, so-called reply, and second, every time I said, but they do not,
Where you have said that this is expression of my personal opinion and will have no bearing on discharge of my official duties.
okay, sir.
We have not been able to find it in page 114. That is your entire stand which you have taken at this in this reply is the stand which will have to be looked into throughout the proceeding. Once the inquiry officer has submitted the report, then you have started making allegation against him also. When you filed this statement at 114, you have not said anything about the inquiry officer that you are proceeding against me with malfide or you are proceeding against me with any extraneous consideration. This you have said when you have filed show cause in reply to the your reply to the show cause issued by the disciplinary authority. So, such conduct from a government servant, that's why we are trying to see. Where have you said this?
Yes, sir.
You are making allegation against the disciplinary authority that you are wasting your precious time, you are wasting my time by embarking on such a charge. So there is an issue of you are also governed by discipline in service.
Yes, sir.
You make such allegation against the disciplinary authority that you are wasting your time and you are wasting my time. Should you be saying this to your disciplinary authority?
So the point was 3, 1 and 2 under
Come see page 2 of your reply, second paragraph. You are saying you are unable to apprehend the true meaning of my quotation. You are wasting your time, you are wasting my time. This is the way a government servant should be communicating with his superior authority. Is it? You tell us. You want your subordinate to correspond with you like this? Would you like your subordinate to correspond with you like this in such language? Or there is an unwritten code or ethics governing the use of language when you are corresponding with your superior authority? It should at least be a sensible narration, polite as much as possible. You are saying the disciplinary authority is wasting his time. He is wasting your time.
Sir, which is under not in the purview and completely personal. He already.
You have not said anywhere. We are again asking you, where have you said this is only personal and this is not a, this will not affect discharge of my public duty? Where you have said this? Just read this line from, this is the least that is expected from you. Because you are a responsible officer. You are not just a layman. You are a responsible officer having many privileges, having many rights, having many powers, duties. At the same time, there is an obligation to maintain a discipline and to maintain a conduct which does not give any scope for anybody to think that you are having any kind of predisposition or any malice or anything. So the least you are required to say is that I have expressed in my personal opinion, this will not have any bearing on my discharge of duty. Where have you said this?
It under this purview when this not that is in duty which was assigned to me. It implies, sir, which is in 37 page, I already stated that in the inquiring authority who has made a speech stated that during the service life.
No. This is after the inquiry report.
Yes, sir.
Not after the inquiry report. Your defense is stated in this document at page 114.
Yes, sir.
This is of which date? This is your defense. This is what is to be considered by everyone. What is the date? This is of page 120.
24 to 2010.
24 to 2021 you have given the reply. That reply of 24 to 21 is the reply which has to be considered. We are not able to find any that you have made any expression like this.
Sir, in first so-called notice which has incorporated the documents, second page 91 in vernacular language, and where I state that যদি আমার ব্যক্তিগত জীবনে সংবিধান মৌলিক অধিকার এবং উক্ত বিধি অনুযায়ী গর্বিত হয়ে সমস্ত কিছু করি, সেটা মানে আমাদের সংবিধানের কোনো পরিপন্থী হবে না। এটা 91 vernacular, but it is I say.
What is it?
Page number 91 in vernacular original language.
What is this document?
In past so-called notice reply.
No, that is prior to chargement.
Yes, sir.
That is not relevant.
The document was enclosed.
Not relevant.
Yes, sir.
What we have said before the inquiry officer is relevant. That is not relevant. That was prior to issuance of charge. That is not going to be considered by the inquiry officer.
Sir, the inquiring officer don't told about how it was happened, but about the Facebook comments matter, which and then I replied, sir, and during his maiden speech, he also said, but he don't mention in report. So I applied in second, third, so cause notice.
Cannot do that. Your defense, whatever you have taken before the inquiry officer, that will remain your defense. Not at the stage of second show cause. Whatever defense you have taken with the before the inquiry officer, because the inquiry is conducted by the inquiry officer.
Yes, sir.
So whatever you have said there, that will prevail. Not anything prior to charge memo, not anything after the submission of inquiry report.
So the same documents which was first show cause, this was included. So already what in brief description, don't exaggerate it in second in charge reply, sir. Already I mentioned in first reply, sir, in show cause, which was enclosed in this charge memo, sir. 8 documents. As they continue with this show cause notice without any giving any my dissatisfaction, and
Yeah, we are still, you have one option. You file a review
yes, sir.
before His Excellency, and you say that this is expression of my personal opinion.
Okay,
It
sir.
will not have any bearing on discharge of my duty.
Yes, sir.
Then it can be considered.
Okay, sir.
That is why we are asking you from the beginning.
Okay, sir. Okay.
We
Because
have not said this
okay,
anywhere.
sir. Okay, sir. Already time has elapsed.
We
And
can
okay, sir.
that we can say that it may be done within the time limit fixed.
Tribunal as
What is the time fixed? Rule 22 has a limitation.
The appeal.
From where you saw that there is a 2-month time limit.
Lordship, there's a limitation of appeals, which is
In the appeal.
that is Rule 17. But for review, I don't find it. Yeah, for limitation of for appeal, filing appeal, there is Rule 17. But for review, Lordship,
Where have you seen the limitation in Rule 20?
limitations of Rule 17.
Rule 22.
Rule 17. Limitation of appeal, sir.
6(3).
Data na কোনটা চলছে? তাহলে এই নাম্বার 15
17 is appeal. 22 doesn't specify any limitation. 22 doesn't specify limitation.
What the thing? This one. Check it.
এটা দুটো কপি দিয়েছিল? দুটোই দুটোই নিয়ে এসেছিল, মানে একটা দিয়েছিল, দুটো দুটো আর নিয়ে আসুন, মানে একটা আমার ছিল, একটা আপনার।
কপিটা তো আলাদা,
এটা আলাদা,
এটা সেম নয়।
একই রকম লাগবে তো? এইটাই কিন্তু রুল একই আছে, যে একই লাগবে, কি জেরক্স করে দিতে হবে না?
এই কপিটা আর ওই কপিটা সেম নয়।
আচ্ছা 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 আচ্ছা। এই এই পার্টটা মতো, এই পার্টটা একই ছিল, এই পার্টটা একই ছিল, পরে ছিল। আচ্ছা আচ্ছা, বুঝতে পারলাম, এটা পরের পার্টটা, এই পার্টটাই বোধহয় পুরোটা ছিল। দেখছি, অ্যাকচুয়ালি তো ডেট ওইভাবে দেওয়া নেই, আমি এইটাই, এই অংশটাই এটা
Lordship, I think is the amendment to the body.
পরে বোধহয় অ্যামেন্ডমেন্ট হয়ে ওই 3 মাসের টাইমটা দিয়েছে, এবারে সেটা অলরেডি লাস্ট হয়ে গেছিল, আগে 6 মাস ছিল, আগে 6 মাস ছিল। না না, এই যে ওটা না, অ্যাপিলেটটা করছি না, অ্যাপিলেটটা আমি করতে পারিনি, হ্যাঁ হ্যাঁ। না, এটা কিছু রুল নেই, ওটা একই আছে। এই প্রথমটা ঠিক আছে, এইটা একই জিনিস ছিল, তারপরে বোধহয় আরো কিছু মডিফাই লাস্ট, সেটা যেটা 3 মাসের একটা ইটা দিয়েছিল, আর ওতে কিন্তু কিছু দেওয়া সমস্যা নেই, হম হম, আর কিছু নেই, হ্যাঁ হ্যাঁ। অ্যাপিলে তিন তিন আগে 6 মাস ছিল, ওটা কমে 3 মাস হয়ে গেছে, ওই জন্য আমি করতে পারি।
What do you want? You want us to pass an order on the merit or you want to avail the remedy? You tell us what you want. If you want to.
As the review questions there, I don't, I actually don't understand, and then review make play for reviews.
Take down.
Good.
I think
Chief, Lordship, I have received instruction, Lordship, in the Hiralal's case, Lordship, it asked me to look into it. I find that the Supreme Court had passed interim order. I mean, subject to the processing of pension, the stay will be granted. Now the order is stayed. It's been extended from time to time. That is what I find.
is it? Let us see.
Lordship, I have no. Supreme Court is a state.
That is the understanding of the authorities. Let us see.
Yes, Lordship. Yes.
Judgment of his.
That is what I get. Plus.
What is your stand before the Supreme Court in Hiralal Ghosh? Just read it from the order.
Lordship, whereby the High Court directed the petitioners to compute the entire service of the respondent for grant of pensionary.
Where is the order of Hiralal Ghosh?
Where the High Court directed the petitioners to compute the entire period of service of the respondent for grant of pensionary benefits under the death retirement benefit rules in 1971. It is submitted that the respondent had put in only about 6 years of regularized service, whereas the DCRB rules require a minimum of 10 years of service. However, on query of the court as to the total period during which the respondent was actually employed in any capacity, learned counsel for the petitioners fairly submits the respondent had been working as a spray worker from 1976 to 2008.
So that is the fairness.
Lordship,
Then,
that was the stand. Lordship.
then
Further on inquiry by the court as to why the period spent prior to regularization, at least to the extent necessary to satisfy the minimum requirement of 10 years, should not be counted for the limited 10 years of qualifying service should not be counted for the limited purpose of entitling him for pensionary benefits. The learned counsel for the petitioners fairly submits that the notice may be issued limited to the aforesaid
correct.
aspect.
That is your submission.
My
Limited to this aforesaid.
Mr. Lordship, paragraph 7 says, subject to the petitioners granting post-retirement benefits, including pension by computing the pensionable service of the respondent as 10 years, there shall be a stay of the operation.
That is based on your submission, your fair submission before the Supreme Court that this will be limited only to the period beyond the minimum period of 10 years.
Only.
In the penultimate paragraph.
And then the order has been.
Then the order has been passed. So
that says.
So when you have taken that stand before Hiralal Ghosh, can you take a different stand in this proceeding? That we are asking.
Lordship,
because the forum is different, therefore you are entitled to a different stand. Because both are DDT spray workers. For both, it is a question of counting the period prior to regularization. There is no distinction whatsoever. There you have taken a fair stand. Here you don't want to take that stand. Is that permissible to a government authority?
Because now that the that is, I mean, as since it's pending, that is what the concerned department, Lordship, has
what happened in that case till now?
Since the Honorable Supreme Court is not holiday is going on, and even then it was mentioned before the Honorable Supreme Court that paragraph 7 has not been complied with. There was a direction within 2 months counting pensionable amount and to be paid.
That also they have not.
In my case also, in Geeta Noshkor's case, I have filed a contempt before your lordship that is pending. Similar, they are totally reluctant to comply as their own stand before the Supreme Court and before this honorable court. Until date, your lordship's order dated 27th of January, categorically directed.
Lordship, to be very candid, Lordship, what I understand by speaking to the officials at this very initial stage, Lordship, I think we need to speak to the finance department. That is the main stumbling. Stumbling.
See why we could have passed an order, but we don't just want to increase the bulk before the apex court. In every case, the moment we pass an order, we know what he will do because we are seeing in all these cases. We expect that better sense prevails. When you have taken a particular stand before the apex court, that you are limiting your challenge to the benefits granted beyond the minimum 10-year period. You have said before the apex court that why the entire period has been directed to be counted. The minimum, for the minimum pension he requires or she requires only 10 years. Why the entire period has been counted? Taking your fair submission into consideration, the apex court stayed the judgment to that limited extent. It is expected that you are a state within the meaning of Article 12, you will take a same stand in all the cases. We don't, where is the order? Can we see a copy of that order?
Of Hilalal.
SLP order, yes.
Yes, well, it is I have handed over. Can you take another copy? We have handed over to quoting that if your lordship takes your lordship's order of 27, your lordship quoted that portion itself. Hilalal, Geeta, all handed over.
No, Geeta we have. Hiral.
Yes, Geeta is also
Paragraph 7.
Mallard. On their submission, that paragraph 7 has been laid down.
No, what is important is paragraph 5.
Paragraph 5 is
Learned
yes.
counsel for the petitioners clearly submits that notice may be issued limited to this aforesaid aspect. What is the aforesaid aspect? That beyond 10 years the period should not be counted. Further on the query of the court as to why the period spent prior to regularization, at least to the extent necessary to satisfy the minimum requirement of 10 years. In response to that query, you have taken a stand that yes, on that limited extent, you may issue a notice. So in effect, you have given before the apex court the claim for the minimum pension counting 10 years. But beyond that, you said should not be done because perhaps the pension amount will increase. We don't know what.
Yes, it will, if the duration is more, then some pension will be.
So they have taken a ground that if you want the period, count the period prior to regulation, don't count anything beyond 10 years.
Beyond 10 years.
Just to ensure that he gets a minimum pension.
That
is the
if your lordship kindly take the stand in Geeta.
No, that order we
That
have.
Geeta is there.
That we have.
Or kindly seize paragraph 2 and paragraph 6. On their submission, Geeta's matter and this Afroja's matter in the same tune, same panel.
At the outset.
Yes, my lord, I am so grateful. I am so grateful.
At the outset.
At the outset.
Petitioner is amenable to the grant pension to the private for the minimum qualifying period.
To the private respondent.
Why you want to take a different stand here?
My lord.
You talk to the finance, whoever you want to talk. We hope you have understand what we are trying, what we are pointing out. We can pass a similar order and keep these matters pending subject to whatever may be decided by the apex court.
That is fixed from the 27th of August. That is what I find from the last.
Anyway, you discuss the matter on this point. You look at these two orders, and we are not recording any order today because we have already recorded. It is already recorded.
27th of January, your lordship quoted both the judge orders.
Yes. The learned AGP
I do not know. Till date, even then they have not complied with in both the matters. And that is why our learned advocate mentioned before the honorable bench. Oh, thereafter in contempt matter, before your lordship directed us to make an affidavit of legalitas because Gita has not expired. So we have also filed the affidavit. Even then, learned advocate, I communicated that. Even then, no payment has been done. So I do not know what type of reluctancy is going on, and one person has died in the meantime. Oh, in Aproja also in bedridden. In this matter. So, 2 weeks. So.
There is actually no ambiguity once you go through the two orders. It is expected that you will take a consistent stand in all the matters. You don't multiply the proceeding and unnecessarily pause the first round. Pass the order by.
My lord.
Because it is very clear.
And on the basis of that submission, it was stayed, but otherwise it could have been, SLP could have been dismissed because Nimai Chand has been dismissed. Well, lordship was aware all these things. And subsequently also, yes, that SLP dismissed. First matter. Then my lord Justice Chakraborty's matter was also available before the Honorable Supreme Court. That also is SLP dismissed. On very that date, we are ready.
Gita Naskar also, they have gone before.
Yes, Gita Naskar also, my lord, your lordship, order papered, and just now, your lordship.
These two judgments were passed by this bench.
My lord's bench. Justice Chakraborty's bench, division bench, SLP dismissed. And earlier, Nimai also, my lord, SLP dismissed.
And these judgments,
in these two judgments,
this limited aspect.
Yes. Since initial submission was there, that is why it could have been heard. Otherwise, when subsequent also, Honorable Supreme Court also.
He knows which way it will go. It may still go back to the situation of Nimai Chand Chatterjee.
Yes, we have to. We have to. We have also made a compilation there. And taking plea of Nimai Chand.
Anyway, whatever is decided,
Let us see.
we will follow that. But as of today, we expect that you take a
minimum pension should be granted. Obliged to your lordship. Grateful.
Item number 3.
Item number 3 and 4.
Matter will after 3.
12,
Yes.
My lord, item number 3 and 4, I am praying for a note today on behalf of Mr. Shumon Banerjee, learned advocate for the
ও 3 and 4 একসাথে সুভাষ দে ঠিক আছে
You are for?
My lord, I am for the petitioner. Mr. Shumon Banerjee is, my lord, the advocate on record. I am praying for a note today on his behalf. My lord, 3 and 4.
together. After 5 this thing.
Item number 5.
Breathe down.
I am for the petitioner. Copy page. अभी तो नहीं चुका
দিয়েছে নাকি দিয়েছি আমি দেখি This is not taken by us.
ছেলে কোথায়
আমার কাছে আবার ওখান থেকে ব্যাক করছে না আনলেস given to somebody. ব্যাপার কিন্তু পাইনি রে দীপিকা মাঝি বের করে দেখো
I have sought this copy. My learned friend is.
No, that signature doesn't come from our chamber. Whoever.
Yes, sir.
Okay, Kunta. Yes, Lordship, I stand corrected. It's been allotted, yes. It's been allotted.
My lord,
Dining happened is. Well, can you see page 29?
Noted, GPT package.
Backward class candidate. Yes, pass high school. Father died.
So whether 3 years can be condoned or not, that is all.
The question, but Mother, can you see page 29? This is the confirmation. Mother, can you see? I have been selected. Next is because of that time, age was 15 years, 17. So he was minor, admitted. Now he is 26. Now the petitioner is 26. That is my case. And we are going to at this tribunal.
Why your mother did not apply?
Mother,
Why your mother did not apply?
actually, he applied. She applied.
He applied for her benefit.
She applied, but due to her health problem, she withdrew and son applied against
Mother applied for
in
son.
the mother. And they have considered, they have approved, but because of age bar, they have not afforded. When against that, petitioner moved administrative tribunal. Well, can you see the order?
Where have you stated on what date the mother applied? Where is that fact in the OA?
Wait. First, my lord, mother applied.
It's not.
Our contention is
See, your father expired on 21/11/2015.
Yes.
When your mother applied. Where is that fact in the OA?
Way is not annexed.
my lord, page 24, no?
Way is not annexed.
No, there is no such, there is.
Yes, yes.
April 2016.
16, we have annexed page 25. In Bengali,
7th April, 4th April. Oh,
Page 25.
25.
Perhaps not 25.
No.
No, Lordship, it
That is
should
the
be,
withdrawal letter.
it is the copy of the application of mother. 27 probably.
4/4/2002.
Lordship, 27 from a letter one couldn't get the date if it's correct.
Mother
11.
applied.
26, page 26, 11/4/2016.
The letter dated 11/4.
2016.
There she says, I applied on 4/4. So the date comes out from there only. Otherwise, there's no
4/4.
document.
That
Yes,
is page
4/4. That is
25.
her letter. She says, I applied on 4th.
No, what does
And that is the withdrawal letter.
say? What does it say? She applied for
But she said she's ill, so she wants to give it to her son.
Out this letter, he wants to withdraw. 11/4/2016. Proceed. Separate yes.
As per letter dated 11/4/2016, she wrote that I applied on 4/4/2016. Now I am withdrawing in order to provide my son application. That is the annexure, page 25.
This was annexed with the OA.
Yes.
How you are saying yes? Where is the way? Show us the way.
ये देवा नहीं तो वो is not oh, yes lordship वो is there वो is there वो starts from page oh no
That is not attached.
what he given me is a copy of
Not attached.
no it's not
Then we will not consider this. Anything else?
Now, my lord, my contention is, now he is 26.
Huh?
Now the applicant or petitioner is 26 years. That may be considered at this stage because he already got the maturity.
That's all.
That is
In compliance to my lord's earlier
Give it
direction,
in-
I have served copy of the
Yes,
petition
yes.
upon the.
Yes, yes.
Position
Lordship.
by file.
Opposition has not filed, Lordship. I have received instructions, Lordship. This also, what I find, again, it's between the department and the finance.
Department
And the finance department, Lordship.
what is the issue?
Lordship, issue is compassionate.
Compassionate appointment.
Compassionate appointment, my lord, the pro forma application submitted after 2 years.
No, when you have filed the OA.
OA was filed, my lord, on 9th February 2025.
9th February.
February.
So where is the rejection order?
My lord, since there is no
February or November.
bench available in the.
No, rejection by the authorities.
Is rejected by the authorities.
Where is that order?
Subject to correction, the OA verification page says 11, I mean, it hasn't been filled up, but it says in the month of November. Then
No.
That's what you mean?
Page?
Lordship, page 37. This is the last page of the OA verification page, which is not filled up, but date is blank 11. That has to be checked. Then if it's 11, then Lordship.
No, it is February.
কোথায় পাচ্ছ বলে তো তোমাদের এখানে 11 করা আছে 11 হলে পরে তো ওটা February হবে না। Then again the whole thing changes. It's filed.
Yes, it is some November 25. Not February.
My lord, I have stated.
So why you did not file a writ petition? Why you have gone to the tribunal when the tribunal is non-functional?
It was filed, your lordship, that's.
No, that's why we asked you at the very outset from where we can get this date that it was filed prior to September. If not, then you go before the single judge dealing with
My
this.
lord, paragraph 15, your lordship, page 10. It is my mistake since it has not been corrected, your lordship. Page 10, my lord, paragraph 15, I have stated, your lordship.
No, again we are asking you whether you have filed after the tribunal became functional or you have non-functional or before that. If you knew that the tribunal is non-functional, you should have filed a writ petition. Why you have gone to the tribunal for getting a passport to come here? Why? What is the date?
Date of
filing?
Date of filing, my lord, 9th. No.
November.
November.
Lordship sees, Lordship will see the orders also. This is dated 11th of
No, my lord.
November.
9th December.
It's
9th December 2025.
Then you file, go before the single judgment.
order is 11th December.
Yes, the the OA also. Because if OA is pending, single judge cannot consider. Yes.
এটার কি হলো?
Both the petitioner are
Single judge bench.
Item number
8, I have to seek an extension, Lordship. We have established contact, the coordination.
Lord, yesterday I argued this, my lord. Only today I pray before your lordship to file one, my lord, short list of dates, and I have served a copy also.
Extension চাইছিলাম for the affidavit. And we've একটা order ছিল। টাইম আছে কি তাহলে তো আর ইউজ হওয়ার দরকার
What is the shortfall?
My lord, 2 months, 13 days, my lord.
What is that?
2 months, my lord, short list of dates indicating the page number. My lord,
There is a shortfall of 2 months.
One.
2 weeks.
2 weeks, 2 weeks.
2 weeks. Affidavit 2 weeks.
29. 29. 29.
29.
next time
Item number 9.
I'm appealing for the appellant in this matter, my lord. My lord, only thing, my lord, if it commences to my lord, if it can be taken up Monday, because I've been engaged in this matter, I could not go through the entire records. For Monday, my lord.
For the state.
My lord, I'm for the state, led by learned GP, my lord.
Let it come after some time. Mr. Chatterjee.
My lord,
Mr. Chair. What is the date of filing of the OA?
The OA. My lord, OA. Yes. No, no, wait. The OA has been filed on
22/5/2025.
So it is before non-function. What is the objection in the?
My lord, objection is that this issue, my lord, there was a charge, my lord, that he had concealed his dismissal order in a previous work, my lord. Now, this issue has been decided by the tribunal once and came before the High Court. High Court upheld the order of dismissal, my lord. Thereafter, in one of the charge, my lord, there was a criminal proceeding pending, my lord. Now, he got exonerated from the criminal proceeding. Now, on the basis of that exoneration, my lord, he has come before the tribunal again. I should be reinstated service. When the order has been upheld, the dismissal order has been upheld by the High Court itself, my lord.
Where is the High Court's order?
My lord, it starts at page 40, my lord.
Page 40 of
affidavit in opposition, my lord.
40-page opposition.
The lordships have got affidavit in opposition on behalf of the respondent, my lord.
Yes, we are saying 40-page opposition.
My lord, two orders are there, my lord. Tribunal's order is a lengthy order, my lord. Thereafter, High Court's order is a lengthy order, my lord. Pankaj Mandal.
আমি এখনো রেডি হইনি ওটা বলে দিচ্ছি
তো হয়নি representation
This allegation led to institution of an FIR also,
my lord, with regard to one of the
charges.
and there were other charges for which departmental proceeding was held,
No, that we have seen. It is based on a charge memo.
my lord.
It is not because of his implication in a criminal case or because of any conviction. It is based on independent charge memo.
Grateful, my lord.
May I just come back? I could not go through the entire. I'll answer, Lord. I noted down his point. I will start with answering his point.
The learned state advocate raises an
July. 22nd July. You
22nd. You have any problem?
23rd.
23rd.
Lord, then Monday, Lord. Yes, the upcoming Monday after 23rd.
What is the date?
Date is 23rd, 26th, 27th. 27th.
List on 27th.
Item number 10.
Yes, Lordship. Item 10, Lordship, I am appearing. Lordship, in this application, Lordship, the petitioner is the Lordship.
So no haste today.
Yes, Lordship.
There is no haste today.
Yes, Lordship. And your Lordship already recorded my submission on 11th of February.
Yes.
Lordship,
11th
একটা
of
thing will be
February.
clear. 11th of February 26.
ওটির কাছে দিয়েছিলাম তারে ওটাও করে দিয়ে এসে গেছে তারা কিন্তু এটা আছে। কিছু করতে পারে।
Opposition is filed.
Yes, Lordship. Opposition file, Lordship. Today I am also handing over the Lordship reply, if it in reply. Your Lordship also on 11th of February, Your Lordship asked one report that was produced before the tribunal.
Yes.
That is Lordship annexing in my reply. If Your Lordship kindly come in the report, everything will be.
Have you given me a reply?
Page number 8, that is
But reply টা একটা দিও।
status report. My main submission is this, Lordship. They have, Lordship, my petitioner's father, Lordship, died on 31st July 2011. And Lordship, the benefit, only Lordship, gratuity, leave salary, and certain amount of Lordship family pension, because the petitioner was Lordship 22 years of age at the time of death. Up to 25 years of his age, certain amount of family pension also disbursed. That disbursement has been Lordship credited in my account on 23rd July 2025. Lordship, my innocuous pair, Lordship, I am entitled to Lordship the interest. That is, I have paid for before the tribunal also. That has not been granted by the tribunal. That's why I am, Lordship, praying before your Lordship to Lordship at least Lordship 8% interest, Lordship, on my Lordship the benefit, because Lordship that is my innocuous pair, and till date I am not received the GPF and GIS amount.
You have said so in your reply.
Yes, Lordship.
Reply আমাকে একটা কপি দিও বাবা।
Where have you stated about the dues?
Lordship, please, Lordship, kindly see. তোমার কাছে আছে, দেখো না।
একটু থাকেন।
Lordship, in my Lordship pair portion, page 14.
Rare portion.
Pair portion, I am paying interest.
You said group GPF and GIS has not been paid. Where is this fact stated by you that this remains due? In your reply, have you stated that these two under the dues under these two heading has not been paid?
Lordship, actually that has not been disclosed in their report. That's why they have disbursed the Lordship. Kindly see page 62. They have given a Lordship letter to me where it is stated that Lordship certain amount of Lordship family pension and gratuity of rupees 4,35,710 and Lordship another rupees Lordship leave salary. No.
He has
And Lordship, in my reply also I have stated page 3.
আচ্ছা page paragraph 14 of the petition, page 9. He has admitted it.
That's why we are asking him from where he is saying that. We have seen, therefore we are asking.
Lordship, kindly see page 3 in my reply.
Reply একটা কপি দাও বাবা।
দিদিকে
এর কপি দে একটা।
দেওয়া হয়েছে আপনাকে। দিদিকে একটা কপি দাও তো রিপ্লাই।
After you finish your argument, give a copy.
Lordship, already I have served.
না reply
হ্যাঁ আছে আপনার কাছে, কালকে দেখিয়েছেন। আছে দেখুন, রিসিভ করেছেন।
Then tell her you have given, why you are asking for giving again.
এই যে দিদি রিসিভ করেছেন, নিন আপনি নিন না, সেটা আছে।
Oh, this was in April.
Huh?
That was in April, Lordship. So it was received by the erstwhile lawyer.
Yes. When have you said that GPF and GIS is pending? Just read where you have stated this.
Lordship, actually, Lordship, after filing this application, they have asked the applicant to Lordship apply for GPF. That was a subsequent event. Lordship, according to their report, I am not Lordship sure under what head I have been Lordship granted the benefit. They have Lordship given in my bank account. That is, I have Lordship annexed that page.
Your husband was your wife?
Lordship, no, I am the son and daughter.
What he was working as?
He was Lordship as a police constable. And Lordship, he died on Lordship 2011.
Wait. So in my reply, page 3, last 4 lines, it is admitted that the petitioners have already received 8,91,032 only till now. It is pertinent to mention herein that petitioners are yet to receive the amount of General Provident Fund and GISS.
Which page? Which page?
Page 3 in my reply, Lordship.
You have applied on in March 26.
They have Lordship asked me, and Lordship told me that it is first you have to apply. We have referred it before the AG Bank. But initially, Lordship, I have applied for all the terminal benefits in the year 2018. But in their affidavit,
Why did you not pay the GPF and GIS?
Lordship, he has applied, Lordship. We've sent the applications. That I find is on March 12th, 3. Lordship sees paragraph 3. The GPF and GIS with the it is pertinent to mention, Lordship, just the last 5 lines, that the petitioners are yet to receive the amount of GPF and GIS.
So there is an application required.
Application is required. He's made it on the 12th of March. That, according to my instructions, that has been forwarded to the authorities. That we have done. So that is not in our hands. He's made the application which has been forwarded to the.
Yes.
Lordship, I have Lordship applied on long back in 2018, Lordship.
What can be done? What can be done? Because of your father, you have suffered.
No, Lordship.
You are suffering because of your father.
No, Lordship. I am Lordship kindly seeing their affidavit in opposition, page number 7. They have also, Lordship, admitted that I am entitled interest, but as because the tribunal has not passed any order, so I have prayed before the tribunal, that's why interest has not been granted. Kindly see page 7 in their affidavit, Lordship. It appears from the order sheet that the Ladde Tribunal that though the petitioner mentioned in the prayer of the original application for disbursement of interest, but in fact the same was not pressed at the time of moving the application, as there is no whisper in the said prayer of the order of the Ladde Tribunal. So the same cannot be allowed and to be raised in the writ petition before the Honorable High Court. I have, Lordship, prayed.
That's all.
And Lordship, another thing, Lordship, the disbursement has not been made, not for my that. Lordship, one criminal case has been, Lordship, lodged against one third lady. They have, Lordship, lost this criminal case in the year 2018. That is not my fault. And they have sanguine that the third lady has made a false representation and claiming the benefit.
That is about that lady.
That regarding that lady. And
that is regarding a lady by the name of Kajal Mandu.
Kajal Mandu. That is no nexus.
Your father married twice with Sandhya Mandu.
Lordship, Sandhya Mandu already that.
Correct. So therefore, they had to make an inquiry whether there is any offspring or not.
That is divorce.
You speak over the court, that doesn't help you. You can speak over the court, that does not help you. We are also going through the things. This Sandhya Mandal, they had to make an inquiry whether she has any offspring or not.
Yes, Lord.
That inquiry was made pursuant to the tribunal's direction in 23.
May I submit on?
The tribunal has passed the order.
Tribunal has, that's why I am challenging this order. Because, Lordship, after demise of first wife, the mother of the applicants, petitioner's father, Lordship, got second marriage. And that marriage has been, Lordship, dissolved by a degree of divorce in the 2011.
It's not the point. It is dissolved, but whether there was any offspring or not, they had to determine.
But why, Lordship, they have...
If there is an offspring, then they would be entitled to a share.
That is, Lordship, they have, if any, Lordship...
When the marriage was dissolved?
Dissolved in 2011.
2011, your father had died.
No, Lordship. Before died, Lordship.
No.
My father died on, Lordship, 31/7/2011.
And you say no? When we say he died in 2011, you say no.
No, 1/7/2011. That is, I have annexed the divorce decree.
The divorce was on.
So that is not in 2011.
In 2011.
Then why you are saying no, sir?
Before death of father.
Why you said no?
It was 24th.
You have to cross everything the court observes.
I am submitting, Lordship.
Why you said no? Tell us first.
I apologize for that. But
you think every observation is hostile to your case?
I want to show the date. Lordship, I have also annexing.
1911.
In 2011, your father died. In 2010, perhaps the marriage was dissolved.
Yes.
That is based.
We have gone through. Then only we are observing. We are not observing.
I am annexing the divorce decree also.
Huh?
Page 26 of the writ petition. I am annexing the divorce decree.
Why you are showing? Who is disputing that? Where is the dispute?
So, Lordship, what I am submitting. After death of my father on 31st July 2011, the cause of action arose, we are entitled to get the benefit as because one third lady
whose name was figuring in the nomination.
Nomination in the name of the applicants.
All three.
Yes, Lordship, all three.
Today, who is the applicant?
Applicant is the Lordship Borun Mondal and his
son,
sister, son and daughter.
No, daughter is not getting anything now.
No, Lordship, your married daughter, Lordship, but she is the Lordship made in the party.
Right now, we are asking you who is the beneficiary? Only son.
Only son.
Wife was predeceased. Wife, your mother was, she predeceased your father.
Yes, Lordship, predeceased.
In 2007, perhaps.
2007, 27/8/2007.
7.
27/8/2007.
Yes.
And their name has been recorded in the service book. Already, Lordship, that is reflected in their report. So that is not my Lordship latches that we have made any false Lordship claim that they have Lordship 1/3 lady Lordship claim that for the said reason.
Sandhya Mandal's name was not entered.
No. Sandhya Mandal's name has not been Lordship. Lordship, that is report Lordship says so. Lordship, in the Lordship, kindly see. Lordship, page 54. Page 54, that is Lordship, that letter has been Lordship produced to me at the time of Lordship moving the matter before the tribunal. First paragraph. With reference to the above, this is to inform him that Constable Torun Mondal was appointed as constable on 5/5/1989. During his service, he married Srimati Jogmaya Mondal. She gave birth of son and daughter, namely Borun Mondal and Taposi Mondal. That is the applicant hearing, Lordship. Where it is recorded that his service book, Srimati Jogmaya Mondal, expired on 27/8/2007, prior to the decease of deceased employee. After demise of first wife Jogmaya Mondal, the said employee got second marriage with one Sonda Mondal on 19/11/2007 and they divorced her on 24/11/2010.
There was a direction of production of service. Is what I told. Case 160/2023. If they know the expression of their names, everything. It would be appropriate to direct the state to produce the service book for the 12/10/2023. No, case 160.
What is the final one? What is the final order passed in WPST 160 of 23?
Lordship comes to page 60.
60.
60, Lordship. A written intimation handed over is dismissed as infructuous. A writ petition is submitted by the learned counsel for the petitioners that OA has now been finally disposed of by the West Bengal Administrative Tribunal on 7th of March 2025.
Then why the writ petition was filed?
No, Lordship, against the interim direction, I have paid for interim Lordship payer. That has not been granted by the tribunal. In terms of that order, I have moved this matter before this honorable court. And as because the tribunal finally decided, next date, the matter has been Lordship withdrawn by this.
7/3/25.
Yes, Lordship, 60.
That is the impugned order here.
No,
7/3/20.
Thereafter, yes, Lordship,
Everything you have to say no first. 7/3/24/5 is the impugned order. Don't say no. That is the impugned order.
First. No. Page 58, Lordship.
7/3/25 is the impugned order.
Yes, Lordship.
Yes. Don't say no.
7/3/25.
Yes.
In way number 277 of 23. Yes, Lordship.
There was no other claimant. Why the tribunal has not accepted the
Page six, page six.
Up towards, to wait as to addictor.
last paragraph, page 2.
There was a
Final order passport. That was
You didn't
the
hear?
implement order. This is the implementation here.
This is the implement. সেটাই বলছে and that was the previous one এর order টা কি হয়েছিল দেখতে
এই তো 22/9/2023
না
Where is the report pursuant to the tribunal's order?
Yes, Lordship. Report I have annexed, Lordship, in the Lordship affidavit in reply. Page 8.
এখানে
No, sir, we are asking you pursuant to the tribunal's order, inquiry was made.
That report I have not been, Lordship, supplied. But Lordship, they have, Lordship, kindly see page 62, 61 and 62 in my read petition. Lordship,
Where is that report? Show us the
61,
report.
Lordship.
Lordship
Page 61. 27.
Pursuant to the tribunal's order.
যেটা এনকোয়ারি রিপোর্ট হলো না এটা ট্রাইব্যুনাল
Lordship, page 61.
এই রিপোর্টটা আছে আপনার কাছে কিন্তু
Page 61 annex kora. Page 61. Lordship, inquiry report in terms of tribunal's order. Page 61.
Just now you said you don't know.
Lordship, that is supplied to me. Page 61.
no this is not a report
এই যে inquiry report subject দেখো।
subject is for after demise thereafter expired you are requested to inform the no lordship this is an intimation I shall produce the
That is-
report then
That is Lordship handed over.
no that is this is the summons for appearing Arun Mondal Tapashi Mondal were called at the inquiry that is the summons
Next page,
lordship then I'll produce the report if necessary
Lordship, next page, kindly see next page, page 62.
Let us read every page first.
No, Lordship, it is clearance.
We ask you a question, see this page, that page, we are asking you, where is the report? You said no, then you said it is at page 61. Now see the next page. You bring that report, that will reveal what happened, why the delay has occurred. There is a direction by the tribunal.
আচ্ছা বাবা হ্যাঁ কত
22nd.
Item number 11.
ভেরি গুড চলো
দিদি কপি নিয়েছি তো
না না না
ওনার কপি দিয়ে
আমারটাই
Go before the single judge bench.
Your Lordship already, my lord, kindly see the my lord, order dated my 25th February 2026, my lord.
Whatever it is, go before the single bench.
How jada?
Their recommendation that is still pending, my lord. That is
For what? What is it for?
regarding fixation, my lord. Regarding fixation, my lord, kindly come to the, my lord, the tribunal application, my lord. Their letters, my lord, kindly, my lord, internal page, my lord. My lord, page 52 onward, my lord. 52 onward, running page, my lord. 52, operative 54 also, my lord. All pages, my lord, their internal correspondence, my lord, but till date, my lord, that is pending, my lord. That is my grievance, my lord, only. As your lordship. If your lordship desire, I will take up.
We cannot make any exception. We are all these matters, we are not entertaining.
I go to the, my lord, single bench.
What is your instruction?
I've not received any instruction, my lord. Just now received the brief, my lord.
No, my lord.
They're seeking 1 week time for the instruction, my lord. I'll take.
As jointly paid list. After 2 weeks, we give you 2 weeks, find out. If something is due, then just
Well, I'll take instruction.
we can dispose it off because it has kept pending.
That is the deep, deep.
59,000.
Thank you.
Item
So item number 12, Lordship, I'm praying for 1 week time, your Lordship. Advocate and record not well, my lord. Advocate and record, my lord, not well, your Lordship.
we are informed by MS so and so.
না না 29 তারিখ
Item number
13, Lordship. I am appearing, Lordship, for the, my lord, I am for the state led by London GP, my lord. Lordship, on 23rd February 26, Lordship, direction given to file the affidavit in, Lordship, opposition and affidavit in reply, Lordship. Lordship, they have supplied me page, or DH,
অপোজিশনটা তো আমরা ফাইল করছি রিপ্লাই
এটা দিয়ে দিচ্ছি। Today I am filing the reply, Lordship.
These matters is filed in January 26. Why will you entertain these matters?
Actually, Lordship, what happened, Lordship, it is filed before the tribunal in the 25. Lordship, OA number is 25, Lordship. But Lordship, after the Lordship, it is admitted that after 8 September it was filed.
Then why you are filing before the tribunal when you know the tribunal is not functional?
That, Lordship, regarding the
You
matter,
are supposed to move the writ court.
Lordship, at that matter,
Just you file it for coming to the division bench.
Lordship, at that matter was pending before the Lordship learned single judge.
Whatever it is, you go before the honorable
Lordship,
single
what
judge.
I am submitting, Lordship, I have no cause fair, Lordship. This matter filed before the tribunal on 26/12/2025. Lordship, Lordship, your Lordship has decided identical, Lordship, 4 matters, and I have annexed that Lordship order. Lordship, I am covered by that order, but till date, against the petitioner, there is a departmental proceeding pending on the same ground. Lordship, my innocence fair, the authority should Lordship dispose of my Lordship pending departmental proceeding on this light of the that order. I have made a representation regarding that issue.
Where is that representation?
Lordship, I have annexed, Lordship. Lordship, page number 148.
So you pursue that representation. The learned advocate for the writ petitioner submit
already to 64 years age, Lordship. Kindly Lordship, certain time be granted. Otherwise, only pending on these proceeding, Lordship, I am not getting anything, Lordship. I have already reached up to 22. আরে এটা তো লাগছে না দিয়ে দিচ্ছি হ্যাঁ একটা দিয়ে দাও না ওগুলো
None appears for the writ petitioner.
Item number 15.
Well, this matter, I'm for the petitioner. I'm paying only 2 days accommodation, my lord.
As paid list after 1 week. Come after.
Month.
Call the next.
15 I appear, my lord, for the state.
For
The state.
I'm paying urgent for 2 days. I'm for the petition.
Why you are not calling the next case when we have passed the order? Why you are not calling the next case?
Item number 16.
Urgent for a week.
Therefore, Sukma Sarkar, I am praying only not today.
Not today. There is met for adjournment list.
Item number 17.
I am for the petitioner. My last occasion, your lordship directed me, my lord, to serve a copy, my lord. I served the copy, my lord, to my learned friend, my lord, to take instruction. Where the, my lord, the petitioner is the wife, my lord. His husband was missing, my lord.
Chip, I filed affidavits in opposition. তোমাকে দিইনি?
Opposition.
Opposition.
Opposition is being filed after service upon the
is serving under West Bengal Health Service.
What happened?
My lord, he has tendered resignation, my lord.
Really?
He has tendered resignation.
No order yet.
No order yet. My lord, your lordship, kindly have a look at your lordship's last order, dated 17th of March. In the order, your lordship has recorded.
Yes. In all the cases, the order is being issued. What happened in this case? Yesterday, we have disposed of 4
Yes.
cases.
Yes, lordship. The orders are being issued whether my learned friend has not, I mean, have started.
No, on 9th June, we recorded your presence and we recorded that you will take instructions
Yes.
in terms of the order of 17/3/26. Month later, there is nothing.
এটা তো আসেনি তুমি, এটা তো instructions নিয়েছো?
হ্যাঁ, এটা
কোথায়?
sub judice এটা। So they are not giving written it.
Sub judice cannot be an instruction.
Yes, right.
Lordship will kindly.
As prayed by learned AGP
হ্যাঁ এই এখনই বলতে পারছি তখন এখন বলতে
Number 20. 20.
Lordship,
It is a matter, my lord, wherein the petitioner come before lordship or willfully disobeying the tribunal's order. A contempt was moved. But nothing happened, my lord, and the tribunal become dysfunctional, my lord. Then we have to move it. But your lordship takes up your lordship's order the 19th of March and subsequent order of 9th of June.
Resignation issue.
Resignation issue, my lord.
For that, you have to file a contempt.
Yes, my lord. Well, initially, my lord, one order was passed, my lord. And there was a rejection order, tribunal upheld. Well, I came before this honorable court. This honorable court setting aside the tribunal sort of limited back again. Thereafter, the tribunal passed an order in my favor.
You have not gone through the files. Earlier, we have granted you time. There is no follow-up. We don't know what is going on.
It's your order. Well, the parent order is at, which is said to be violated is 133.
21/7/25 order.
It's 21/7/2025 order.
They have not challenged it also.
No, madam.
And they are not complying with it also. What is the issue? We don't know. Why it has not been complied? Now in all the matters, after we have passed one order,
now
in all the matters, they have been accepting the resignation.
started lordship, I have to seek instructions on these codes.
Many
Whether
times it has to
there
be.
been any change because the compliance has started from June, July like that, lordship. Not prior to that. So maybe there might be some
Time for
progress.
filing a report.
Jana.
Yes, sir.
And 21.
My lord, I am appearing for the Public Service Commission.
My lord, for item number 21 and 22, my lord, the advocate record has some personal difficulty, my lord. He could not come to court. Can it be taken up next week, my lord, any day? Next week, any day, my lord. Next week, my lord.
Learned advocate, Mr. So-and-so.
Parent 22.
22 is my lord.
Same.
Parent 23.
23 lordship, I am paying lordship 3 times lordship.
Same order. Not same order, as prayed.
24.
My lord, for item number 24, my lord, the advocate on record is not present in court, my lord. My lord, I have been instructed to pray before your lordship to give liberty, my lord, so that this WPST can be withdrawn and fresh WPA can be filed, your lordship.
The learned advocate.
Disposed. Next up. WPA.
Parent 25.
25 also, my lord, I will be saying same thing, my lord. It's filed on 10th of October, but I get from the FFA.
Same order.
Same order.
Just what we have passed. Same order to avail the remedy.
Both the OA
Number, please.
and the OA number is, my lord, 591 of 2025. 91 of 591 of 2025.
Parent 24.
But 26.
Now appears on behalf of the petitioner. Stop.
Dismiss for default.
Parent 25.
25 হয়ে গেল 25 হয়ে গেল
না না ওটা ডাকে গন্ডগোল করেছিল রেকর্ড গুলো তাই
25 my lord, not that matter 510 it was filed after the tribunal becomes defunct, my lord. So your lordship allowed me to withdraw and move
25.
25, my lord.
lordship just passed the order.
Just now your lordship was passed.
So where did he review?
Record গুলো disposed of.
What is happening?
24 disposed of হয়েছিল 20 54 25 ওটা
Just now you had given us the file of 24. What is the case number?
6, my lord. Petitioner. Now, my lord, on the last occasion, your lordship passed an order on 24th of June 2026. Now, my lord,
But I beg to appear for the state in the matter.
now, my lord, I find that certain documents, my lord, which are very relevant for the purpose of deciding the matter have
Yes,
been.
we had told you, ask someone to why you are not.
I say, my lord, with the greatest of my respect, my lord, I have prepared a supplementary affidavit, and my lord, I am serving a copy upon the state. My lord, kindly record an order that the supplementary affidavit be kept on record.
You are also for the respondent.
Yes, madam. I'm being led by Mr.
It's okay, দিয়ে দিচ্ছি।
Lordship, I don't think such voluminous documents will be required, since on the last occasion, my learned senior friend said that he's not pressing for. But this can be disposed of. That is why I'm trying to make this submission.
No, kindly
If it is
take it any
agreeable-
day in the next week.
আচ্ছা আচ্ছা
ও এটাই বলতে চাইছি, আমি তো সে থেকে আমাকে বলেইছি।
আমি আপনাকে স্যার দেখিয়ে দিচ্ছি ওর পেনশনের জন্য ইজ এন্টাইটেল
But the last order is for only citing judgments now.
there was no leave which was granted to the petitioners to.
You had confined your relief and then we had adjourned it for citing judgments. Then why this supplementary is being filed? We are not granted any liberty for filing such voluminous supplementary.
না
At this stage, after the argument, how a supplementary can be filed?
if I may be permitted, Lordship, I just 30 seconds. So, Lordship, on the previous occasion, my learned senior friend submitted that he's not pressing for notional benefit of pay because of no work, no play.
That is recorded.
That is recorded.
Yes.
That is recorded. Now I've taken instructions. I've sat with my officers. He's now what my learned senior friend was stuck at was the pension.
Yes.
Now, with respect to pension, he's entitled to pension.
Yes.
However, he is entitled since he's completing. There are two sorts of pensions. One is the complete notional half pension, which is after completion of 10 years of service, and the other pension is full pension, which is after completion of 20 years of
20 years.
service.
Yes.
Now he's falling within that 10 years and 20 years bracket. He's not crossing the 20
Less than 20.
less than 20 years. He's falling short by around around 8 odd months. Lordship, if I have prepared this dates.
So then what remains? Why such supplementary, voluminous
Miller,
supplementary?
I say, Miller, what happened? Truly speaking, Miller, I should indicate to my lords. Now, Miller, on the last occasion, when this matter was taken up, certain annexures were very illegible.
But that's hardly relevant now. You have confined the issue and they are willing to pay. Then what is the issue?
No, I
On
am.
that pro rata basis pension, he's entitled to it.
Miller, I just
So I'm not
only
joining
indicate-
any issues on that at all. So this can be disposed. I'm so sorry, Lordship. I'm lost the second copy.
No, you take it back. So if there is anything remaining after this, stand by the state. Is there something remaining after
Miller,
this?
just let me take the instructions.
All right.
For the
That will be
satisfaction
the
of my
better.
learned senior.
Grateful. Lordship may kindly fix a date.
Yes. No case is without a date in this bench. Every case we fix it.
27. Grateful.
In this matter, I am appearing for the petition.
Yes, I have to. But
Time for filing opposition is
Item 28.
My 28, my lord, I have the petition. So there's a direction to file an affidavit, my lord. Time was extended once. There's a second extension, if I may say, my lord. But your lordship may hear me out, my lord, I can place my case. If your lordship hear me, so I can place my case, my lord.
I'm filing the affidavit.
date of filing.
No, my lord, it's 2024 matter. Its OA number is of some 2024.
Affidavit in opposition is filed.
Twenty-second.
22nd. পরের বুধবার।
22nd.
এলকুটু দেখে পাই।
29.
There is none to represent the writ petition.
Item 30.
There is none to represent the writ.
Item 31.
Lordship, I appear for the petition. There was a direction, my lord, for filing opposition.
Yes.
Like here,
Is it
my lord,
ready?
31, my lord.
Is it ready?
Only thing, my lord, the petitioner is not getting his salary from December, my lord. এটা হচ্ছে তন্ময় চ্যাটার্জি। Lordship,
Go through it.
Lordship, I would like to respond to it. I mean,
That's why we are saying go through it. Opposition is taken on record.
great.
Item 32.
In this matter, tomorrow
What is the date of the interim order?
interim order dated
Till tomorrow it will subsist.
Yeah.
16.
Nobody is appearing for the state.
My lordship, I am for PSC.
Copy served.
GP office.
GP office time.
Mr. Sahasrangshu Bhattacharya.
Sir.
Yes.
Advocate General has made party, my lord.
Huh?
Advocate General has been made party because the process of selection for appointment to the principal of the technical college was initiated and appointed in violation of the AICT rules, my lord. So I found from the record file, আপনার কাছে আছে file টা, briefটা?
আমার briefটা আছে।
The Advocate General has also been implicated as a party, my
The
lord.
rule is under check.
So the copy as is required to be served upon the Advocate General.
That has been served earlier also.
A press copy will be served, new Advocate General coming.
How long this will go on?
Next week. On next week.
No, it is not a very casual thing. Last day you have said Mr. So-and-so is appearing at journey to render proper assistance. Today you want a copy?
No, actually, I have been instructed by the department that Advocate General should.
You are Mr.?
Yes.
You are, we don't know, sorry, you are Mr.?
Sahasrangshu Bhattacharya.
Oh, so you didn't appear on the last day?
Well, I'm junior.
The earlier advocate was appearing.
I'm a junior.
Who is Mr. Arga Chatterjee?
Arga Chatterjee.
So he's your junior, and you were represented.
Yes, my lord.
Then why this casual attitude of the state? We don't know in every matter.
Because this problem is that
No problem. 2 months have lapsed. That is well over. Your cup of accommodation is full. Set your house in order. This can't go on forever.
there is an interim order for which, my lord, the entire selection of the principal of.
Because of you.
Yes, my lord.
You are not ready.
Yes.
Even today you are not ready.
No, it would be better, my lord, if the order for exchange of affidavit is passed, then the matter will be concluded, my lord.
What is the order on the date on which we passed the interim order?
Interim order of 5/2000.
Already we are directed for opposition.
Opposition already done.
Then what you are saying, a direction needs to be passed. We have already passed an order.
Yes, interim order is there. Interim order is
No, there is also a direction for opposition being filed. Mr. Bhattacharya. If you give it, it will only expedite your thing. Give a copy.
Already given it.
Today
Today I will serve. Today I will serve.
My lord, item number
I'm for the
33,
respondents, madam.
led by Mr. Jayantanaran Chatterjee, appearing on behalf of the petitioner, my lord. My lord, there is a direction to file a opposition, my lord, affidavit in
My
opposition.
lord, if I may submit, my lord, the petitioner has claimed for all terminal benefits, my lord. That has been duly paid, my lord, by June, my lord, 2026, my lord. After my lord's direction, all payments has been made, my lord.
Where is the order? Where is the order of payment?
He has claimed, my lord, so we are directed to, he has claimed that terminal benefits may be released, my lord. So in the meantime, my lord, the department has already released all his payments, my lord.
Now what remains?
My lord, kindly make it not this week, my lord. Fix a date, my lord, kindly.
You see, we are adjourning it. You get revised instruction. Why we are saying? You have authorized provisional pension. You have paid the arrears of provisional pension. But the GPF was required to be revalidated. Whether it has been done or not.
The last page of that, my lord.
Yes.
2nd of July, my lord, he has got the entire amount. 9
Last
lakh
page.
Last page of the this bunch of documents that I have handed over, my lord. The GPF amounting to rupees.
This is, you don't bother to read the documents before you hand it to the court. And when we point out, then also you don't understand. That is of 21.5. Just see this, what this says. Please read this.
Yes, my lord, I have copy.
It has to be revalidated. Keep it with you. We are informed that
Number 34. 34, my lord. For the applicant, my lord, this is my affidavit of service. My lord, this matter is pending before set, but still, since my lord, the bench is not there, for that reason, my lord, we have.
what is the date of filing?
My lord, this one has been filed on 22nd April 2026.
Before the tribunal?
No, this has been filed before the.
No, before the tribunal, when you have filed it?
My lord, before tribunal, my lord, 3rd November 2025.
You have to go before the single judge bench. Same order, which we are passing in all the cases. When it is non-functional, why you file there? You should have filed a writ petition.
Yes. But give me that liberty, my lord.
We are doing it in all the cases. Yes. See, on these matters which are pending since before, we are interfering. Otherwise, you had the remedy. You are well before the single judge.
As a lord. Yes. As a lord.
Yes.
But 35 also same.
Next case.
Service
Same order.
Same বলছে।
দিদি আপনি পঞ্চাশ আছেন?
আমি সবাই মিলে গেছি।
So we are, because you cannot withdraw the OA, therefore in all the cases, we are disposing of the OA also to enable you to avail the remedy before the trial.
And it will be filed before second as a lot.
35 also, right?
35.
36.
36 I appear. Same fate.
Same order.
37 Mittal.
37.
37.
What happened? 36. He is appearing 36, huh?
আমার ঠিক কথা ছিল।
No. This matter, this was matter was pending for the tribunal.
Yes, what is the issue?
In the tribunal, matter was heard, and it was heard in part, twice. But the time of passing of the judgment or the further hearing the bench is bracket. You also kindly see the last order passed by the tribunal so that I can.
So you waited for 11 years, 10 years, then it became urgent.
Matter was heard in length and the part, matter was heard in part by a particular bench of the learned tribunal. That bench was subsequently transferred or got limited the office to send to another bench. There also matter was heard in part. Kindly see just only one order. I would like to show you also. Entire order will be annexed. Kindly see order dated 9 June 2025.
September.
Put that matter on 13th November 2024. Matter was heard in length and it was made was part heard and fixed for further hearing. Kindly see order dated 13 November 2000. The entire fact has been narrated in that order. ফাইল করেছি এই মাসে ফাইল করেছি আমি দিয়ে দেবো
Distribution to yellow. হচ্ছে এখন 37 তোমার কত?
Where is 77 EMP?
77 EMP, my lord, I'm showing you.
77 EMP dated 5/6/2009. Where is it?
My lord, I'm showing. My lord, page 75.
No, that is not it.
Yes, my lord, 77 EMP, 1st July 2009. Page 75. Creation of 158 posts.
We are asking you 5/6/2009. You are showing us 1/7/2009.
That is not with me at this present moment.
So how you can claim this vacancy? Therefore, we are asking.
But if you also kindly see page 75 once, then I will show to the.
We are looking at 75.
158 post was created.
Not for you.
For the similar.
We don't know. That was created by 77 EMP dated 5/6/2009. And that you are withholding from the court and tribunal.
But may I just read one paragraph?
You may not. You read the first paragraph, then you read anything else.
Of 150 post, a female word.
That is not the first paragraph. That is the subject. Consequent upon.
Approval of the accord by the labor department. So
Yes, the approval is 5/6/2009 that you are withholding from the court, and you are presuming that this is for you.
This notification was published to lordship give appointment to regularize.
You can keep on submitting that. We have made our query very clear.
But this notification I do not have right now.
Unless you show that how anyone can ascertain.
Which time I produce. Kindly give me.
You were appointed in 2008 and 9. Immediately this memorandum will come to your aid for regularization.
No, but what is my prayer before the learned tribunal is that
absorption. What else?
158 post was created.
Forget about the details. Number is irrelevant. You got appointed as an extra warder in 2008-9.
2008.
And this decision will come to your aid for regularization. Wonderful case you have made out.
But what case made out before the tribunal is that we are working since 892.
That is not your case. You are appointed in 2008-9.
Yes.
And don't say 88-89. You are not from 88-89.
You are appointed in 2008 and 2000.
And 1 year after that, you will be regularized. Wonderful.
Filed this application in 2015, saying that you.
How you can affirm this? We are asking you. This memorandum, which has come into existence 1 year or at the time of your appointment as extra warder, that will come to your aid for absorption and regulation.
I'm not saying for absorption or regulation, in particularly in dot.
What is your prayer? Come to your prayer in the way. That is why you have kept it pending for 10 years. Now we have understood.
Prayer is at page 43.
Please read.
Direction to issue upon the concerned responding authorities to forthwith grant absorption.
Yes, wonderful. So into this memorandum of 2009, which was issued when you were just taken in as an extra warder.
2013.
Huh?
2013 memorandum.
No, this is your basis.
2013 memorandum. I'm sorry to your lordship. It's 21st June 2013.
How that will improve your case?
Kindly come to page 82.
That is nothing, that is just a communication, recommendation.
The government says,
We have seen it, sir. We have seen it. By the time we have seen it, that's why we are focused on that document which is relevant to your case.
there are
In 2008, 2009, some of you were appointed as extra warders. In 2009, a decision has come for absorption of those who have been working since decades. You say, take me in this because there is vacancy available. Wonderful. And you have kept the way pending for 10 years. And when the tribunal is not functional, you have come here.
highly consider these aspects. But we are also working for now decades.
Keep working. Who is stopping you? You are very fortunate if you are working. Much more fortunate than many others who have no work.
For the last,
That's not the point whether you are working or not. How you can rely on, you cannot rely on this. We can dispose it off right now.
Government says,
We can dispose it off right now. Show us whatever you want to show. Show us.
but we are relying on the page 82 because the government, the secretary himself says that they can be absorbed.
You can be. We are also saying you can be.
But they let them consider our prayer then.
Why? Why we should give a direction?
There is a recommendation of the joint.
To approach them, who is
But
stopping
we
you?
have made a representation before that.
You pursue that
But
representation.
that was not considered. That's why we filed a original.
We don't know. We are not going to create any right by directing for disposal of a representation.
We filed a representation before the.
There is no
That was
obligation.
not considered.
There is no obligation.
For the tribe.
There is no obligation.
But then will kindly grant us liberty to file a representation that they will consider.
You may do whatever you want.
Because we filed a representation that is pending.
$38. Yes, sir.
My lord, the issue is decided by lordship, my lord, and
Then why you have filed the writ petition?
my lord, actually the matter is pending for more than 10 years, my lord, before the tribunal, my lord.
What issue?
Issue, my lord,
Which issue? Tell us. We don't remember. Which issue is decided?
my lord, in the case of Hirilal Ghosh and in the case of Alochana Pan,
Oh,
you lordship
you are regularized after continuous service.
pension and minimum pension, seeking minimum pension.
What the tribunal has done?
Tribunal, my lord, after 10 years, my lord, it is adjourned again. My lord, my certificate copy has been annexed, my lord.
So when you were regularized, sir,
In the year 2009,
and you retired when?
in the year 2015 or 2015.
And you were working for the, prior to that, for how long you were working?
From 1974. And Alochana Pan has been dismissed by the Honorable
How many
Supreme
of
Court.
you? How many of you?
My
Say,
lord,
how many petitioners are there?
one,
What do you say? What are you saying? What has been dismissed by the Supreme?
Alochana Pan, state preferred special petition before the Honorable Supreme Court.
Alochana Pan.
Alochana
Who
Pan.
is that? Which case?
That judgment, my lord, your lordship has been pleased to pass
Oh,
regarding the same issue.
there are so many cases on this issue.
And Hirilal Ghosh also, your lordship passed the order, my lord. Hirilal Ghosh
And Geeta Muskar.
and Geeta Naskar. Hirilal Ghosh also interim order is passed, my lord, to give minimum pension to the petitioner by the Honorable Supreme Court, my lord.
Still they have not paid.
But have misled the Honorable Supreme Court that your lordship has passed order notional benefit from the very beginning to last.
No, they have
But
not
your lordship
misled.
only was pleased to give minimum pension.
They have not misled.
Nothing more, nothing more. So interim order also was passed in that matter also.
Yes, but still they have not complied. Despite the orders of the apex court, also they have not made a payment.
Complied, my lord.
Today we were informed in the first half. That is why we remember. That in
Hilalal Ghosh complied. Alochana Pan.
Interim order is extended.
Alochana Pan, my lord, dismissed, my lord, Honorable Supreme Court, my lord.
Which was that matter today?
Hilalal Ghosh.
In the first half,
Yes,
do you
in the-
remember
yes,
which matter
yes,
it was? We'll list on that very same date.
My lord, page 219, my lord.
This
It
morning.
is probably two. Afrozat Begum.
When we have addressed.
It is on the 5th, 12th August.
He let it come on 12. She has got, the Leonard AGP has seen those orders. She has said that she will discuss with the finance secretary. To give
Their
the minimum
finance is also
pension
not a part.
as has been given in the case of Hira Algu. So let her come back with instructions. If they are agreeable, then nothing to be.
But Hilalal Ghosh is still pending before the Honorable Supreme Court. But Alochana Pan is dismissed. Dismissed by the Honorable Supreme Court.
Very well. List on 12th August. On that day, the other case will also come up, so that day we'll take it up.
Yes.
We hope that better sense prevails. Let's see what happens.
Item 39. I'm for the respondent state. Just now I received the brief from a learned friend, and learned that there was an order to file a report in the form of affidavit,
This is also matter related to resignation of a doctor.
Resignation.
Resignation.
Keep the order of, this morning 4 orders have been issued releasing them. All these cases now the state has been releasing them. How you can withhold a resignation? You have no power to withhold a resignation. After 3 weeks, as paid by the learned advocate, as paid by learned advocate.
PSC 3.
Get the order released.
2024
If there is requirement to file any report in the form of affidavit, since the issue has already been decided.
You can come with the report, you can come with the order. In most of the cases, they are serving the order and he is withdrawing the.
But just now I have, at a glance, I have seen the file that since 2022, he is not doing the order.
No, he will lose. Resignation means past service will be forfeited. What he has not worked, he will not get paid. Those things are, you have to accept the resignation.
Examine that.
পুরোটা সেটেল করা আছে
কোনো দেয়া আছে 29
but a similar matter about fixed on 29th. Can this be on 29th? 29th. হ্যাঁ পরেরটা
Item 40.
I appeal for the petitioner. In terms of your last order, my lord, I'm filing the supplementary affidavit. Wherein the parent circular is lordship has asked for the bring that circular on record. It's a copy of it. On a copy of the review service. আমাকে একটা কপি জেরক্স করা ছিল করা হয়নি
So you were on probation.
Yes, sir. At that point of time I was on probation.
What is the period from 21 to 16 to 36, 17?
Yes, sir.
What which provision you are relying upon?
My lord, if your lordship takes up the circular and my lord, I also say, my lord, if you look at on teasing order, passed in case of a similarly circumstanced person of the finance department, they were, my lord, we are warders in correctional services, and those persons are excise constable in the finance department. My lord, I may say, but the finance is the interpreter of these circulars issued by the finance department. Now, there the principal secretary says, if it is been this recruitment process is taken out by the recruitment board other than the PSC, now then they are entitled to get the HRA and DA. If it is done by the PSC, in such situation they are not entitled to. Now, in our case also, we have been recruited by the same recruitment board, by which the excise constables were recruitment, that is police recruitment board. So, my lord, I may say, my lord, they have created a class among class. But by one set of employees are getting the benefit and the others were not deprived of. And we fall in the category of deprived employees, my lord. But if your lordship takes up the recent order of the excise department, at page starts from 84, 85 is the recent order, my lord. Your lordship kindly straight away come to my lord. 87. My lord. The page 87, last part, your lordship will find. যে কপি দিয়েছিল বিষ্ণু জেরক্স করতে হবে খেয়ে দিচ্ছিল নিয়ে করে দিচ্ছে একটা ছবি তুলে নিয়ে বাড়ি করে দিচ্ছে সব কপি আছে আমাদের কাছে
আপনাদের নেই কপি নেই এই তো সাপ্লিমেন্ট
হ্যাঁ এদিকে দেওয়া আছে সেটা ঠিক আছে কিন্তু সাপ্লিমেন্টারি কপিটা পেয়ে গেছে এটা আমারও করতে এটা নোটিফিকেশন আমি করেই রেখেছিলাম
কপি সার্ভিস করেছিলেন হ্যাঁ হ্যাঁ দেখে দেওয়া আছে
So you are claiming the benefit under which provision that we are asking?
My lord, if your lordship takes up, my lord, or the circular or the order, my lord, which is annexed with the, my lord, supplementary application, my lord. My lord, the rule which has been annexed with the supplementary application, if your lordship takes up.
That talks of only those persons who have been recruited through the PSC.
Yes, my lord, PSC or my lord,
or commission.
Staff Selection Commission.
Yes.
No, my lord, what
You have admittedly neither you're recruited by the Staff Selection Commission nor the PSC.
By the PSC, I'm by the West Bengal Police Recruitment Board.
So therefore, that does not apply to you.
That it doesn't apply if, my lord, if this circular says somebody who is appointed, they are not entitled to get HRA or DA for the first period of probation for 3 years. So, following that, my lord, although we were not recruited by those two agencies, still in our case, my lord, that was done. And my lord, this circular was applied, I may say, my lord, and my lord, for that period, we had not been paid the HRA or DA. But if your lordship takes a paid notification, my lord, 8.8, withdrawal of salary during period of probation. During the period of probation, only the entry point pay, i.e. the basic pay plus grade pay of the concerned group C or service or cadre or category shall be allowed with annual increment of 3% and medical allowance if any. It stops there, my lord. Yes,
Next page. Next page. Take annex করা আছে?
Supplementary.
It applies to all services. It does not say it applies only to those who are appointed through PSC.
No, my lord, if your lordship takes up, my lord, 0.7, selection procedure. Selection shall be made on the basis of competitive examination to be conducted by the Staff Selection Commission West Bengal or
This rule applies to one and all. It says that selection is to be done like this. That does not mean this rule is applicable only to them. These rules shall apply in case of appointment to any post or cadre or service or category belonging to group C.
Yes, my
It
lord.
has a very wide.
My lord, if your lordship takes up the resident order passed by the principal secretary.
Forget about it. That is for those employees, they have taken a decision. You are relying on which provision? That we are asking you.
But I'm beseeching subject lordship kindly, my lord. But I may say, my lord.
From where did you get this notion that you will be getting an HRA or this D? From how you got this notion?
My lord, what I beseech is this, my lord, what I get from this. My lord, even, my lord, what I say, my lord, even after this, what of টাকাটা পেয়েছে? My lord, with regard to the area component, my lord, they have already paid me with arrears with regard to, my lord, the DA part.
Page 92.
From 2016 to, my lord, whatever the date may be till 2019, in terms of the government, my lord, the government's order, they have paid the arrears.
Where is that?
My lord, if 92, my lord, this is the lordship takes up. My lord, I have just shown, my lord, with regard to two of the incumbents. Page 93, your lordship takes up once. This is of the petition number 1, Shamol Gonai. At the top, your lordship will find calculation of area pay and allowances, Shamol Gonai, unique ID number such and such, for period of such and such to such and such. My lord, DA has been paid.
No, where is DA?
My lord, your lordship will find there is a column, installment number 1, thereafter installment percentage, pay details, DA. At the left hand side, my lord, your lordship will find DA 86270. Total pay 860, deduction 0.
This is not a DA amount. These arrears of pay and allowances.
Now, this is in terms of the Supreme Court's order, my lord, which the earlier government said, my lord, they will be going to pay from 16 to 19, and the latter one we paid, my lord, which is.
And you were appointed on probation in which year?
In year 16, my lord.
Very well.
My lord, 21, মানে শ্যামল গনাই, my lord, 21 to 16.
সবাই all right.
মানে শ্যামল গনাই একজনকে বললি তো বল।
ওরা একসাথে থেকে দিচ্ছে আমার প্রভিশন 71 আর বিগ পেজে একসাথে
There is an order of the tribunal to make such payment.
It is not, your lordship will find. With regard to HRA, my lord, there is an order of the tribunal.
75.
That is, my lord, your lordship takes up page 75, my lord, if your lordship takes up.
ওরা দিয়ে দিয়েছে ইয়ার এটা
This is your way.
Yes, my lord, they have in terms of this order, they have paid the rational allowances, but HRA DA, my lord.
There is no order. There is a direction to.
Simple direction to consider, my lord.
So from where do you sustain your claim? On what basis?
My lord, subject to my lord, what my understanding says, my lord, practically by passing two different recent orders, my lord, the state has created a class among class. My lord, I may say, my lord, that is also arbitrary and my lord.
We don't know. They are not before us. What was their terms of appointment? What was the appointment letter? Under which rule they were appointed? Whether it contemplated any such grant? We don't know. The equality can be claimed amongst equals. Because some have got it does not mean you must also get it. So where is how your claim is enforceable through a direction that we are asking you? A positive direction has to be issued based on which document? Is there a rejection by the authorities?
Yes, my lord, there is some rejection.
Where is the rejection?
My lord, that is, your lordship will find. My lord, that is page 77. Let's start from page 77, my lord.
So therefore, tell us what is wrong with this order.
Last my lord, thereafter, after the leasing order was passed, my lord, if your lordship kindly takes up once, my lord, page 90. My lord, this is a communication made by the ADG and IG of Correctional Services. My lord, he is the, I must say, the directorial head. My lord, to the additional secretary, my lord, wherein a proposal for disbursement of area DA and HRA to all 33 water applicants in OA number such and such. My lord, this is in relation to other, my lord, dated after.
What happened on this proposal?
Proposal কি হয়েছে? Thereafter, my lord, nothing has come out, I have been told.
No, thereafter DA has been paid. You just now said DA has been paid.
88 DA, my lord. I require, my lord, the HRA.
So therefore, out of two components, one has already been paid.
To certain extent, one has been paid, my lord. I may say.
Why you say certain extent?
Initially, my lord, I may say, my lord, but there are certain litigations were going on in this court and ultimately went up to the Supreme Court. My lord, the learned tribunal initially passed an order giving DA a specific amount of DA for the period of 2009 to 2016. My lord, thereafter litigations were, it continued till 2019 when, my lord, ROPA 2019 came into force. My lord, the government is to pay the DL 7 except the amount which is decided by the learned tribunal, affirmed by this court, and it went up to the Supreme Court, where also the tribunal's order was affirmed by the Honorable Supreme Court. But thereafter contempt petitions were moved. Ultimately, my lord, the last government, my lord, just few days before my elections were declared, my lord, they said, my lord, they will pay the area DA to the tune of 50% from 16 to 19. So, my lord, the area DA which was directed by the SAT to pay or the tribunal to be paid, my lord, now they have paid, not the original DA. The area DA part, my lord, they have paid. Now, my question, if the area can be paid, why not the original?
So, what is the original?
My lord, এটা কত percentage দিয়েছিল?
You are appointed in 16 only.
16 only, my lord.
So 16 onwards, they have already paid. Then what is the area?
My lord, initially the government, I may say, my lord, I just give an illustration, my lord.
What are you trying to say? Only 50% has been paid.
I give you illustration, my lord. If say, my lord, there was a DA during that time, say take 20%, my lord, tribunal directed to give it 40%. So what they did, my lord, they go on paying 20% till, my lord, the Supreme Court contempt petitions in the Supreme Court were taken out. Now they are paying the rest 20%, which they have not paid, but during 16 to 19.
So area's difference has been paid.
Absolutely, my lord. So if they can pay the area's difference, my lord, I may say, my lord, subject to ship kindly, why not that part, my lord, where the area even starts?
Where you have said that DA has been paid, so from your pleading.
Then I have to petition it. My lord, I'm just coming, my lord.
Come to your OA.
Let's say, please. OA to nahi. But this was, my lord, this allowance was provided after the OA was filed. My lord, this, my lord, your lordship will find page 90, which I have annexed. My lord, page 92 or 93. Or 90 होता था এটা সাবস্টিটিউট মানে ফর্ম আমাদের তো দেখি আমাদের কবে দিয়েছিল এই এই যে 89 এই যে 21 2 থেকে 30 6 মিনিটে দিতে একসাথে অলরেডি পেয়ে গেছে মানে if your lordship takes up page 89 once from 1/7/2007 we are getting everything. We got the 2017 1/7/2017. In terms of this 4th April order, my lord,
Claim is from February 16 to June 17.
17, my lord. From 1/7 we are getting everything, my lord. We have no dispute with regard to 1/7/17.
Therefore, tell us, where is your right? Based on which document, which rule, which provision, which terms in your appointment letter?
appointment letter থাকবেই না এই অর্ডারটা 70 কি বলা আছে
You cannot claim a positive direction to make a payment by way of inference. So therefore, we are asking you repeatedly, where is the right which can be enforced by issuance of a direction?
Well, can it be on Monday, my lord? Let me check my external one.
As played.
But I
Supplementary affidavit, my lord. My brief, my lord, I couldn't find my copy.
Lord, I have asked my learned একটা কপি দিয়ে দেবে
আমি আপনাকে কপি next day I will file in, I will serve a copy, my lord.
41.
ওনাকে দিয়ে দাও করে দিয়ে
non-appeal.
Number 42.
So I am applying for the instrument number 2 and 11.
Yes, you are for the
So number 2 and 11.
none appears for the writ petition.
My lord, led by Mr. Manali, Miss Manali business. My lord, 42, my lord. Item 42, my lord. I
Yes.
am praying for 1 week adjournment, my lord.
Why you are taking adjournment in
My lord,
installments? Take it once. We have adjourned it 4 weeks. Every day you want an adjournment. Come after 4 weeks. Yes.
This is a record. Item 43.
Yes.
Tabular D
সার্ভিস করেছি নতুন করে
তো But the point is very short. If the state comes up with not the proper short affidavit, can dispose of.
What is the date of filing of the original application?
Well, 28th of August when that was functional.
August. From where we gather this date?
With the order to that.
Because the first order is of December 25.
24. Kindly turn to page 24.
Date of filing.
What the date of filing?
Stamp man.
No, we are talking about the original application.
Yes, that is page 24. This is the
Page 24.
by the West Bengal Tribunal received on 28th of August 2025. The original application is filed.
Very well. So what is the issue?
Short. As per the government notification, if I complete 21 years of service, I am 25 years of service, I am entitled to get the scale 21 benefit, which they did not give me. I had to move it. In the meantime, my lord, I have superannuated. But I am entitled to get this benefit. Ultimately, financial benefit will come to me.
If there is any rejection by
Nothing. They are sitting tight. Therefore, my lord, I say if the state comes up with the file, that can be disposed of within a day. What are the reasons for withholding my 21st scale benefit?
we are beseeching your attention in the matter. What is to be done?
To be briefed formally.
No. Mrs. Alam is appearing, but brief is not.
No, she had appeared on the last day also. In all these matters, we are granting a second adjournment to you.
চাঁদনি কে দেয়া আছে সব
না ওনাকেও সার্ভিস করেছি
ওকেও তো দিয়েছে বলছে
না আপনার রুনু দিকে আপনি তো রুনু দিত হ্যাঁ আমি সার্ভিস করেছি আপনাকেও হ্যাঁ দুবার করেছি স্যার
It's about time. I mean, you are taking too long to set your house in order. Every day you are frustrating the court proceedings. How long this can go on? 2 months is not enough to set everything in order.
কবে করতে পারবে বলো
Next week,
What will you do on next week?
next Tuesday, my lord.
I'm ready with the paper.
What will you do? What do you want? You want next week for what?
Not
Let the learned AGP obtain instructions. Just check, just check if copy is with them or not. Otherwise, again, it will be adjourned. This is becoming very frustrating.
All matters.
Yes. Oh, she is here. Just speak to Miss Alam is here. You can speak to her.
Pilot, she has.
Yes, call the next. Call the next.
44.
My lord, copy is there.
No,
instruction আছে
Devashish Das.
Instruction আছে
I'll have to report. I'll file it. File a report. File. Okay. 5th August. 5th August report file. ঠিক আছে ঠিক আছে
Neither parties are represented. Stop listening.
Item 45.
The appear for the
44.
There's some matter pending before the apex court.
export has been disposed of.
Disposed of. So what is the relevance of that disposal?
That the Honorable Supreme Court has held that notwithstanding the pendency of the writ petition or not the proceedings before the court, if the status of the juristic entity has changed, qua the Article 12 point, then not writ petition is not to be entertained.
Not to be entertained.
During the pendency of the proceedings, Air India has gone a substantial change insofar as its structure is concerned. It's now a private
Disinvested.
Disinvested.
So then we are to proceed.
You are the appellant in the.
You are Air India. What is the issue?
A scheme for regularization was directed to be implemented. This was in respect of helpers who are the ground staff. Now, at one point of time, sometimes in 1997-98, a panel was prepared for the purpose of induction of helpers in various categories, namely transport, stores, purchase, etc. For some reason or the other, that panel was not being acted upon because there was a several, the volume of work was also being looked into. Till such time, a batch of those impaneled candidates filed a writ petition. We decided to extend the life of the panel from time to time till 1994. Now, in 1998, there was a writ petition filed.
No, you said till 94. That means beyond that it was not extended.
So it says that up to 15 July 1994, the validity of the panel was made.
So there is no order extending it after that.
But in 1995, there was a writ petition filed. Seeking for consideration of the petitioners for appointment in respect of the vacancies declared in 1989 process. Now, that during the pendency of those proceedings before this court, we came with a scheme for regularization, a proposal for implementing a scheme. The scheme was that all existing and future vacancies would be filled up by the impaneled candidates.
89 impaneled.
89 impaneled candidates. Subsequently, this was modified to give a prioritized right to those persons in terms of filling up of vacancies.
Prioritized rights means some relaxations.
They would have in the event of filling up, they will be treated on priority basis. A preferential treatment.
Preferential treatment.
Not for the existing and future vacancies as well.
No, but would they be required to participate in any process or no? Okay.
Now,
so for regular post.
But the matter had gone up to the Supreme Court. But ultimately, the division bench had directed the scheme to be implemented. So the division bench had set aside the scheme by which the respondents were directed to be given a preferential treatment. So that order was set aside by the Honorable Supreme Court. Now, next came the demand for implementation of the scheme. So regardless of the prioritized treatment or preferential treatment, they wanted implementation of the scheme. Now, at that stage,
yes,
we said that we are not in requirement of such number of employees. And although there was a panel prepared by reason of the reduction of volume of business or not the aircrafts manned by or operated by Air India in the various domestic as well as the international airports, we don't require this number of employees. So that was the defense taken up at that stage, sometimes in 2002. Now, then another writ petition was filed, where the service, by way of an interim order, the service of those gentlemen were protected, not to disturb their services. So that matter went up, and we were also restrained from appointing outsiders. So that ultimately had gone up to the stage when in 2012 the order under appeal has been delivered.
What is the order?
So that's at page, it was, in short, that's National Airport Company of India Limited was directed to give effect to the scheme for regularization. That's the first direction in the order.
89, 89 scheme.
And not the act of regularization to be taken as a one-time measure. So the matter had gone up to the Honorable Supreme.
When this order was passed?
This was passed on 3rd of April 2012. But we had
No one-time exercise was taken after Uma Devi 3.
No.
So therefore probably this order was passed.
Now, not in the meantime, not what probably escaped the notice of the Honorable Bench was that the volume of operation had reduced substantially. And not there were good and justifiable grounds for not filling up those vacancies on a regular basis.
So that is the order impugned before us.
And the other point is during the subsistence, I mean during the pendency of this appeal, that the structure of the company has undergone a change. And that's exactly what the Honorable Supreme Court has delivered. Now, that's the order which your lordships are probably taking note of. The matter was adjourned, I believe, on the ground of the Supreme Court pendency.
No, last day you were not here.
No, I was not. No, I was briefed only.
No, nobody was here. None appeared.
I am sorry.
We are not saying you. You are not represented.
But some other High Court had delivered a judgment from which it had gone up in appeal before the Honorable Supreme Court. The Supreme Court held that notwithstanding the pendency of the matter, if the juristic entity has gone a change, then writ petition should not be entertained.
But what about orders which have already been passed prior to change of the entity?
Not those, in my most respectful submission, had not attained finality. But the principle of res sub judice may probably apply.
And what is that judgment? You have the details of the judgment passed by the Honorable Apex Court. The issue number 3.
Yes, not the brief facts are at paragraph 4, and what the issue is at, yes, issue number 3. And what the answer is at paragraph
39.
37, 38, and 39.
Earlier respondents were represented.
Not the,
Yes, Mr. Indrajit, Mr.
Chatterjee and
Ravindra Chatterjee was.
I shall inform you.
Yes, take down. The learned senior advocate.
Number 57 and 58.
Yes, we are for the petition.
This matter was practically when the hearing was concluded, but in the meantime, change of guard has not completely put it into disarray.
এই ডক্টরকে বোঝাও তো আপনাকে বুঝিয়ে দিই
আমার বোঝানো হয়ে গেছে
Is it, so what should we do?
It depends on him. If he comes,
Prayer for regulation of the lecturer working on contractual basis, my lord.
No, we are asking you, what should we do?
I am ready. I am today ready.
And let us proceed.
So the prayer is, my lord. First I am placing the prayer, my lord.
You were here when the argument was being advanced.
Yes, yes.
When the argument was being advanced, you were here.
no.
And you are saying you are ready.
He's adventurous. His name is Sahasrangshu. Your lordship knows. We have two, and he has Sahasra. That's the problem.
বলো তুমি বলো
We are blind.
Has to be.
Yes. You should make your submissions in his presence so that he can.
But my point, I just briefly I'm making that
This is that matter where three parameters we had,
yes.
and the fourth parameter according to you was to be established. So
Because
just
my-
if you can just briefly, for his benefit, if you can submit.
No, I just am telling you, basic question. But the appointment was made following the fair and transparent method. There was an advertisement. Through advertisement selections were made. They are all qualified persons, though they were appointed on contractual. They have been continuing that for last 20 years and several years. I just can't get it. And after, and since they have been continuing following the Supreme Court the recent judgments, Lordship wanted to get clarified, and three issue I am told it was argued, and apparently I could satisfy your Lordship. Now kindly come to me, Lord.
So you are working since 2007.
2007.
You were appointed pursuant to a walk-in interview.
Yes, through an advertisement, not Milord secretly. The open public advertisement.
Yes, there was an advertisement in the newspaper, if you remember correctly.
And when they are sanctioned post, all the criteria laid down by the Honorable Supreme Court for regularization has been fulfilled. Page 37, and the better copy is 37A. It was published in a National Daily Telegraph on 8th of November 2007. The qualifications are all qualifications which were matching with the regular recruiting qualification. That is one of the query from the court.
Whether it is the qualification specified by the regulatory body or.
And
who is the regulator? AICT?
Therefore, they are qualified, they were appointed, they have been continuing. Now, Milord, at this stage, these highly educated persons cannot be said that you cannot continue. I mean, you have to continue on contractual basis. Therefore, what remains? I give him these indications. If he comes ready, I can also supply with the latest Supreme Court judgments, which really had considered by your Lordship. The list of the judgments. You know, get a copy.
কপি দাও না
Copy দিতে পারবো?
দাও না কপি দাও না
Relying on Jago and Dharam Singh and
Bholanath.
Bholanath.
এতগুলো The similar issue has already been considered by this honorable court in another division bench.
These are also argued. These are also
So
argued.
wherein
The prayer for regularization of the contractual lecturer has been considered and rejected. I can hand over the judgment, my lord. On my instruction, I have been instructed to place this judgment before your lordship.
So this was also placed by the earlier GP, and that was also considered by your lordship. Page 180. That is a part of the pleading itself. The second table.
Or the subsequent change of situation. Winter change. We take it.
Taking it up after such a long time, we need to refresh a bit.
Kindly fix a date, please. I shall.
Any date we'll fix.
One thing, just I want to add, my lord. Just now, my learned friend placed the work-in interview notification, where from it appears that the initial recruitment has been mentioned for a limited period. I am just pressing. Work-in interview will be held at Siliguri Government Polytechnic Siliguri, Central Government for engagement of lecturer in government polytechnics on purely contractual basis. So the argument that, my lord, that there was a sanctioned post and the selection was made in accordance with the law. So walk-in interview is not permissible in case of recruitment to a permanent post, my lord. And the purely temporary post, it has been categorically mentioned in the notification that the post is purely, the recruitment is purely temporary. If we go for that, all the engagement letters annexed by my learned friend's client, my lord, the petitioner.
We just observed something. We need to be refreshed. It has been a long time since the last two adjournments. We need to just.
And next week,
on that day, both sides make your submission. We'll finish it.
Let it be concluded in one day. No further.
Yes, no further time. We have already given us the judgments. We have seen these judgments. This one also we have seen.
Yes.
So we just want to take note of the relevant date and facts, and we'll conclude it.
Fine.
When should we have it, Mr.
Supreme Court.
Next week,
20. Yes, 20. Good, Let any date, my lord, commencing 27th.
আমি এখানেই থাকবো, যাবো না।
List on have a list of dates there.
তখন আর বিষয় করে দিয়েছে খুব অসুবিধা। 58 7 and 58 absolutely.
Very brief, very brief.
Item 46. Yes, well, I am for the petition. My lord, there is an application for consideration along with the condonation of delay. (192 days delay, my lord, in filing restoration application.
Rising out of tribunal's order.
Yes, ma'am. Yes. Very old matter, 2013 UA has been filed. And 2023 matter has been dismissed for default. For the tribunal, there are two grounds, my lord.
Yes, so the only issue is whether benefit of the memorandum 16(9) can be extended to outsourced employees or not.
Yes, yes.
So tell us.
Kindly see the impugned that order, page 61.
Yes.
My lord, in this order it is written, in order to provide security of tenure and appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual daily rated contractual worker who have remained engaged in various government, not appointed by the government, government establishment, in Lane Tribunal says all daily rated employees who are the petitioner, who are appointed by the government. This order says who are engaged in, appointed by various authorities, but engaged in that establishment, they are entitled to get that benefit. It is not the question of appointed by any government establishment.
Understood. Not necessarily appointed by, but in the government.
Yes, my lord.
Now, what are other point?
And all these, they are working till
the government.
Till now.
Till the government.
Yes. Till now, they are working under the public health engineering department, and all identity card issued by the assistant engineer. And there are no mediator. There are no contractor. Now they are under the assistant engineer.
It may be that at the time of appointment, maybe there are some mediator, but now there are no contractor. They are now directly working under the assistant engineer. And till now they are working. They have been appointed in the year 1999. Since that day till today, they are working without any break. So they are entitled to get that benefit. It is my only prayer. And after 2011, there are several government order has been issued. And in this regard, if my lord permits me to file supplementary affidavit.
No, sir, not at all.
Yes, ma'am. There are several government order have already been issued in this regard. Twenty, 30 years they are working without break. There are other governments order after 2013 have been issued by the government in this regard.
Where are the identity cards?
Page from page 34. Page 34 to page 59 and page 60 is very much important, my lord. The BLO, the BDO already issued that they are working. Kindly see page 60, the certificate issued by the BDO, Block Development Officer. Page 60.
Yes, take down. Application is
47.
Lordship, I am for the appellant. On the last occasion, this is a matter wherein criminal departmental proceedings were stayed because the criminal case was lodged. It had fallen from your lordship that uh, if I could place what is the stage of the criminal trial and how I wanted to file a supplementary affidavit bringing on record the FIR, the charge sheet, and the complaint that was filed by us regarding the departmental inquiry. That how both the FIR and the departmental proceedings are not on the same cause of action. The criminal trial that has been initiated, it has been filed. What had happened? This is a RPF in the Metro Railway. He is an RPF police person wearing a police uniform. He is working. What are the allegations against him? That he with a knife injured some person. And right now there has been, I took out the past antecedents. What are the antecedents after the incident also, whether there were certain incidents that had happened or not, because accused is being allowed to wear a police uniform, your lordship. If the departmental proceedings are stalled, the accused is being allowed to wear a police uniform, and this may occur for other incidents. So that is the reason I'm praying, let me place your lordship on affidavit, file a supplementary affidavit and distinguish your lordship how the criminal case and the departmental proceedings are not the same, because the criminal case was lodged by the concerned person who was agreed.
You filed an opposition before the single judge.
No, your lordship. It wasn't done.
So there is only an interim order, it has finally been disposed of.
There was an interim order and it was finally disposed of. The then advocate did not file any, it is recorded that he did not file any affidavit.
Therefore, we asked you, what is the stage? First, tell us
the stage, your lordship, is that it is at witness stage. 4 to 5 witnesses have been examined.
How many are remaining?
There are, I think, 9 total.
No, total 2 to 3 are remaining. Only the prosecution witnesses are praying for time, and for that reason the matter is being stalled for so many days. The prosecution witnesses are being
and the complaint has not been lodged by us. It has been lodged by the person who was aggrieved with the knife.
We have seen, we remember now. The proceeding is also in respect of the same allegation.
Your lordship,
he has accosted and he has assaulted. If he is identified in the departmental proceeding, what will remain?
Your lordship, which are not common in the
not be, but that finding, once it is recorded, it will be to his prejudice. If it is
wins in the department in the criminal trial, the departmental proceedings have zero value because of the latest judgments, your lordship. Because if he wins in the criminal trial, even if he will be
That's not the issue arising for consideration. The issue is whether he can be prejudiced at this stage. That is the only issue.
Your lordship, but it is not.
There is no issue that the both cannot run parallel. They surely can. He may be acquitted in the criminal trial, still convicted in that also it is possible. But at a time when the criminal proceeding is pending, if the departmental proceeding proceeds,
it's not on the
nature of the allegations. Oh, it is.
We have initiated the departmental proceedings that he is not, there was dereliction of duty during office hours. Yes, there is a mention about the assault by knife.
We have seen it, we remember, that's why we are saying.
There is a mention.
There is overlapping, it is overlapping.
There is overlapping to that effect.
Therefore, how can he disclose, or how can anyone hold him to be the same person?
If lordship allows us to conduct the departmental proceedings, and we will not pass the final hearing, and it will be subject to your
what is the point? Then what is the point?
Your lordship, meantime, or the concerned
does not have an ego against him. So what is the point if you will not pass the final order? Then why you should proceed?
Happen that this person will retire meantime the criminal trial is over because of the criminal trial stage.
Why you are not producing the prosecution witnesses? Therefore, we asked you to show the stage. You must come clean before the court. It is in your hands. You are not producing the witness, and you are saying that
the criminal case has not been lodged by us. It is lodged by the person who was aggrieved by the knife, who was assaulted by the knife. We didn't lodge the criminal case.
The victim has lodged.
The victim had lodged the criminal case. We did not lodge the criminal case. Our witnesses who were common, only 3 witnesses are there. I checked that fact as well. What are the common witnesses in the criminal trial and our trial?
But
in the
if you
departmental
remember
proceedings.
correctly, the Honorable Single Judge has taken note of this aspect that his identification is vital.
These facts were not brought before the honorable single
It is,
bench.
his identification is vital. If they hold in the inquiry that he is that person, then
Your Lordship, charge sheet has already been filed. So all that investigation is over by the police authorities.
that may cause some prejudice. There's only
Your
the
Lordship
likelihood.
allows me once to place on record the documents of the FIR, the charge sheet, and these are not on record, Your Lordship. Thereafter, Your Lordship may
Very well.
consider.
As prayed by learned advocate for the Union of India.